Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner. Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Ortlicker.
Here.
Assemblywoman Summers Armstrong. Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. We do have a quorum. I believe Assemblywoman Krasner is in the building and should be joining us shortly, so I'll note when that happens. And Assemblywoman Summers Armstrong is also running just a little bit late. So if we could mark those two absent excused until they arrive. And again, I'll try to remember that. So good morning, everybody. Good morning, members of the committee. Good morning, members of the public who may be watching on the legislature's website or on our YouTube channel. I want to welcome you to day 44 of the 81st session of the Nevada Legislature. Before we get started on this morning's agenda, just a few housekeeping matters. For those on the Zoom, could you please mute when you're not speaking? That'll help with the feedback we sometimes get. And then if you could also remember to state your name each time you speak, particularly for our presenters, if you could remember to state your name after you are asked a question, that'll help with the preparation of the minutes. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That is perfectly fine. We just need to make sure we're being respectful of one another, of the legislative institution, and most importantly, of our very hardworking staff. Finally, many of the members will be using multiple devices to access the meeting. That includes desktops, laptops, iPhones, iPads, and the like. So please don't see it as a sign of disrespect if members appear to be looking away during the meeting. They're most likely trying to access committee exhibits or read bills that way. So this is just the world we live in for the moment. With that behind us, we will move on to our agenda. Members of the committee, members of the public, you'll see that we have two bills on the agenda today. We are going to take those two bills in order. So at this time, I will open the hearing on Assembly Bill 58. Assembly Bill 58 makes changes relating to the authority and duties of the Attorney General. And before I turn it over to Attorney General Ford, I wanted to let the members know and members of the public know there is a proposed amendment from the Attorney General's office that can be found on Nellis under the Exhibit tab. So welcome, Attorney General Ford, and I see you have your team with you as well. So welcome back to the Assembly Judiciary Committee, and when you're ready to begin on Assembly Bill 58, please proceed.
Thank you, Chair Yeager. Good morning. And before I begin, Assemblywoman Kasama, you are correct. Daylight savings time is taking its toll. I still feel like it's 7 o'clock, and I would have only been up 6 minutes in any event. That's a joke. Really, I would have been up a long time ago. Anyway, it's good to see you all, and thank you so much for having us. Good morning again, Chair Yeager and members of the committee. For the record, my name is Aaron Ford, and I am your Attorney General. Joining me virtually and in person are members of my staff, my Chief of Staff, Jessica Adair, First Assistant Kyle George, Second Assistant Christine Jones-Brady, and Special Assistant Teresa Harp. I believe Second Assistant Christine Jones-Brady will be joining us shortly. While I've long since been an advocate for and worked on criminal justice reform, our efforts reached new urgency after the killing of George Floyd and the public outcry that immediately followed. Most of us in law enforcement are horrified, saddened, and angered by the videos of police brutality. We do not want to be associated with bad actors or, quote, bad apples who use their status as law enforcement to act above the law. But we cannot use the phrase "a few bad apples" to excuse law enforcement officers who have engaged in excessive force, unlawful policing, or who have openly violated the constitutional rights of individuals. After all, the entire saying is one bad apple spoils the barrel. The objective of a pattern or practice investigation is to identify the barrels and to reform practices and patterns of, among other things, excessive force, bias or discriminatory policing, or violations of any constitutional rights, including our First Amendment rights to peacefully assemble, or Fourth Amendment rights to be free from unreasonable stops, searches, arrests, or other seizures. Pattern and practice investigations will allow us to effectively determine whether claims of misconduct were one-off instances, isolated instances by individual officers, or whether there are symptoms of larger deficiencies within agencies' customs, training, or culture. Before I turn to the bill, let me tell you what it is, and what it is not. Our goal here is not to, quote, name and shame, unquote, law enforcement agencies. That would only further deepen community mistrust. Rather, this bill is about accountability. It's about fixing problems where they exist. These investigations allow an agency to remedy identified problems, rebuild trust between the police and the communities that they serve, and strengthen lawful and effective policing practices. It also allows officers to ensure that they have the training and policies they need to be the best law enforcement officers for their communities. The United States Department of Justice currently has federal authority to conduct pattern and practice investigations of state and local law enforcement agencies. Since 1994, the US DOJ has conducted 70 investigations into police departments, which have resulted in 41 reform agreements or court-ordered consent decrees. In January of 2017, then Attorney General Jeff Sessions announced that the US DOJ believed that these investigations should rightfully be conducted at the state level. He also said that the DOJ would no longer conduct them. As part of this new posture, the DOJ issued new guidance that limited the scope and usefulness of future consent decrees. Since January 2017, the DOJ has not initiated a single investigation into a law enforcement agency and has only entered into one consent decree from an investigation that began in 2015. To be sure, as administrations change, so may policies. But even if the DOJ, under newly confirmed U.S. Attorney Merrick Garland, were to resume exercising its pattern and practice authority, there are other reasons to pass this bill at the state level. First, and obviously, this tool should not depend on the whim of a particular administration. Having pattern and practice authority reside at both federal and state level, at federal or state level, doubles the likelihood that public complaints will be reviewed or investigated. Additionally, this bill addresses one of the shortcomings of the federal investigatory authority, namely the lack of subpoena power. Under the federal version, if an agency declines to cooperate, the DOJ is limited in its ability to effectively gather information. This version remedies that shortcoming. It should also be noted that Congress is currently considering passage of the George Floyd Justice and Policing Act, which would extend the DOJ's pattern and practice investigative authority to the states. My understanding is that the bill has passed the House of Representatives and is now being considered by the Senate. But this fact does not obviate the need for state action in this area, principally because the Nevada Attorney General's office is more familiar with the people and agencies of our own state than the federal government. To our office, home means Nevada, and we have a vested interest in ensuring Nevadans are safe and that their constitutional rights are protected. My office is also better positioned than our federal partners to understand the diversity of communities and local agencies across the state. Point in fact, realizing these benefits and because of Attorney General Sessions' call to do so, other states have given their attorneys general the ability to conduct pattern and practice investigations. And even more states are seeking such ability to this day. Today, we are asking you to add Nevada to that list of states that has given their attorney general, their attorneys general, the authority to conduct pattern and practice investigations. The bill before you today is a culmination of a collaborative process between law enforcement leaders, police union representatives, law enforcement management, district attorneys, members of the criminal defense bar, the ACLU, and community organizations and organizers. I want to thank the following stakeholders for their countless hours that they spent and put in on this amendment and for their support. And they are the Nevada Sheriffs and Chiefs Association, the American Civil Liberties Union of Nevada, Las Vegas Metropolitan Police Department, Clark County Public Defender's Office, Nevada District Attorneys Association, Nevada Attorneys for Criminal Justice, Washoe County Sheriff's Office, Washoe County Public Defender's Office, the Nevada Police Union, the Reno Police Department, the Las Vegas Police Managers and Supervisors Association, and the Nevada Association of Public Safety Officers. There are countless others who've also offered input, and I thank them likewise for their input and support. For the purpose of walking you through this bill, we will be working off of the amendment that Chair Yeager highlighted a second ago and that we filed with the committee. I'll start out of order with the most significant change in this amendment, and that is Section 3 of the bill, as introduced, is now stricken. That is, my office is not at this point seeking concurrent jurisdiction over certain police misconduct claims. In all honesty, having engaged in some important introspection, my office determined that we ourselves needed to shore up our own ability to fulfill our statutory task of investigating and prosecuting misconduct committed by state officers. My brethren in law enforcement have graciously agreed to assist us with the training and tools to do so, and I want to thank them publicly for doing that. So this bill will only address pattern or practice authority. And in that regard, subsection 1 of the amendment provides that no law enforcement agency or agency responsible for juvenile justice shall engage in a pattern or practice that deprives people of their rights under the U.S. or Nevada constitutions or any other law. Subsection 2 provides that the Nevada Attorney General's office may investigate claims that an agency covered by this bill has a pattern or practice of violating people's rights. This investigatory power is discretionary. If after an investigation has been conducted, the Attorney General has reasonable cause to believe that there is a pattern or practice of unlawful policing at an agency, the Attorney General must first notify the agency of that belief and the factual basis for alleging the agency has a pattern or practice of unlawful policing. The agency then has 30 days to respond. The goal here is to start a productive dialogue between the Attorney General's office and the agency to identify the pattern of practice that is unlawful or any systemic deficiencies at the agency, as well as to work with the agency to correct those deficiencies. The agency will in fact have 60 days to make good faith efforts to change the identified deficiencies. In the event the Attorney General's office and the agency are unable to agree on a plan to reform the problematic activity, the Attorney General has the authority to initiate a civil lawsuit against the agency. The court would then be empowered to impose an injunctive relief, compelling the agency to adopt certain corrective measures or to stop certain actions. Please note, this bill is limited to injunctive relief only and does not call for monetary damages. I also want to make it abundantly clear that this investigation and authority to bring a civil action is directed at law enforcement agencies and not law enforcement officers. Agencies still rightly retain the power to discipline their own officers, and local city attorneys and district attorneys still rightly retain the power to prosecute an officer who is alleged to have broken the law. This investigation takes a comprehensive look at the agency as a whole, and if necessary, the action brought is a civil lawsuit, not a criminal prosecution, against the agency and not against a particular officer. In that same vein, as Attorney General, I recognize that my own agency must also be accountable to the public as any other law enforcement agencies in this state. And for that reason, subsection 3 requires that the Attorney General's office participate in any federal practice, pattern of practice investigations of the Attorney General's office. This is important because, as I stated earlier, the federal law that gives the DOJ pattern of practice authority does not require agencies to cooperate in an investigation. But this bill would legally require the AG's office to cooperate with any federal investigations of our agency and peace officers. Subsection 4 allows the court to enforce the terms of an agreement between the Attorney General and an agency to remedy and identify a pattern of practice that violates the U.S. or Nevada Constitution or any applicable laws. Subsection 5 addresses the investigation itself. And in this regard, before an Attorney General can notify an agency of an identified pattern of practice, it must conduct an investigation and have a factual basis that shows that there is indeed an unlawful pattern of practice. But investigations are only as good as our ability to collect evidence. For that reason, subsection 4 grants the Attorney General's office the power to subpoena witnesses, documents, and other information held by an agency, authority similarly granted to several other units within the Office of the Attorney General. This subsection also provides for judicial oversight over the use of the subpoenas in exercising powers pursuant to this bill. On this point, I want to emphasize two important aspects of this subpoena provision. First, the subpoena power extends only to evidence maintained by the agency being investigated. It does not extend to an officer's personal devices. Secondly, I want to make it clear that the subpoena power does not displace long-standing constitutional considerations against self-incrimination, such as the Fifth Amendment and the Garrity case. Subsection 6 makes explicit the Nevada whistleblower statutes are applicable to this bill. That is, it prohibits retaliation against a state or local employee who discloses evidence of an unlawful pattern of practice. Subsection 7 requires that at the conclusion of a pattern of practice investigation, the Attorney General must publicly disclose one of three conclusions. One, either that the agency does not have an identified pattern or practice of unlawful policy, or that that an unlawful pattern or practice could not be factually substantiated by the evidence in an investigation, or third, that the agency does have an identified pattern or practice of unlawful policing, and it has either agreed to rectify that pattern or practice in ways laid out in the report, or that it does not agree to rectify the pattern of practice, and that the AG has decided to file a civil action. These public reports are important for accountability and transparency of taxpayer-funded agencies, and they will help to augment, restore, or create public trust in law enforcement. Subsection 8 addresses the confidentiality of the investigation itself. While a final report will be made public, the details of the investigation will remain confidential. Some of the information gathered in a pattern of practice investigation will be highly sensitive and could compromise active criminal investigations. For example, investigative materials could identify the personal details of not just the individual officers, but also of civilians who have interacted with the police. A lack of confidentiality would undoubtedly lead to a chilling effect on people being willing to come forward to disclose information about unlawful policing. That said, confidentiality can be waived by the disclosing party or by a court. That concludes my presentation on the provisions of AB 58 as it is proposed to be amended. Were this bill to pass, and I hope it does, it's important to note that the pattern of practice authority this bill grants will clearly not solve all the problems. This bill is just one tool in the toolbox to help build a better justice system in Nevada, but it's one that works. As a law enforcement leader, I've had the pleasure of working with other law enforcement leaders across the state who are ready and willing to take up the mantle of reform. In fact, we heard from many of them during the Justice and Injustice Forum that my office held in the immediate aftermath of George Floyd's killing. It was indeed refreshing and reassuring that law enforcement stated with one voice that Mr. Floyd's killing was unjust, and that we needed to recommit ourselves to adopting tools to again augment, restore, and create trust between law enforcement and the communities we serve. This bill is a direct result of that recommitment. We're not afraid of high standards or excellence. We're not afraid of public scrutiny of our methods and actions. And we're not afraid of examining those parts, patterns, or practices of our agencies that can and should be better to protect and serve all communities in Nevada. And with that, I thank you for your time and for entertaining this bill, Mr. Chair, and I look forward to answering any of your questions. Thank you.
Thank you for your presentation, Attorney General Ford. Before I go to questions, I just wanted to thank you and your team for the hard work on this bill. You listed off the organizations, some of them that you had worked with, and for members of the committee, if you have it in front of you, the title page of the amendment lists those organizations. And as chair, I just want to say thank you, because I think we reached out to your office the first week of session to inquire about this bill and whether it was ready to be heard. And we were advised that work was ongoing, and here we are, I think, in week 7. So I think that clearly is a reflection of a lot of input from interested persons in this legislation. And I know that's not easy to do, particularly in the world we're living in right now. So I just want to express my thanks to you and your team for getting us to where we are today, which I think is going to make the hearing a lot smoother. So I certainly appreciate that. I have some questions so far. I have a list going, but before I take the first one, if members of the committee could show me by a raise of hands who has a question, and I'll get a list going here. And we'll have an opportunity for additional questions as well. Let me just kind of put it together a list for the moment. Okay, so here's who I have so far. We'll start with Assemblywoman Gonzalez, then we have Vice Chair Wynn, Assemblywoman Bilbray Axelrod, Assemblyman O'Neill, Assemblywoman Cohen, and we'll take it from there. So Assemblywoman Gonzalez, please go ahead with the first question.
Hello, thank you so much, Chair. Good morning, Assemblywoman Gonzalez, District 16 for the record. I have 2 questions. So in the beginning, Attorney General, you stated that there was a notice. I was wondering, or like how the process starts. Is it a notice that someone has filed something or that your office has something, or is it a notice of investigation? And then a follow-up second question, after, say there was an investigation, you guys fixed the policy. Is there a follow-up from your office? Like, do you check in post-investigation to see if the policy or person changed their behavior or changed the policy? Thank you.
Very good questions. Aaron Ford for the record. Assemblywoman, thank you so much. Let me first say that the notice that I was speaking of in my presentation was notice that this office gives to the agency about a complaint that we would have received. So I think possibly there were, I don't want to conflate these issues, but we would get a complaint in our office, for example, from someone arguing an instance of police misconduct. That complaint in and of itself may be insufficient for us to institute an investigation into a pattern of practice. But if that complaint is accompanied by facts that do, in fact, enable us to look into it from a pattern and practice perspective, then we would pursue it that way. If we were to receive several complaints, for example, and we don't want to put that suggestion out that the people should just be filing several complaints for the heck of it, right? But if these are legitimate, credible complaints, we would institute an investigation, but that begins with notice to the agency itself. So that's the notice that I was talking about, Assemblywoman. To your second, and by the way, to the extent my team down in Las Vegas wants to chime in, they can do so.
Yes.
Chime in before I go to the second point.
Thank you, Attorney General. Thank you, Assemblywoman Gonzalez. Jessica Adair, Chief of Staff for the record. In regards to notice, the specific notice mentioned in the bill is a notice to the agency that the Attorney General's office has conducted an investigation, and the Attorney General's office has a reasonable cause to believe and a factual basis to support that there is a or one or more identified patterns or practices of unlawful policing. So at the conclusion of an investigation, the agency receives that notice that's mentioned in the statute or in the amendment that the investigation has concluded. And here is why we believe that you have an identified pattern and practice with our supporting factual basis. So after an investigation is concluded, the agency receives that notice. And then the agency has 30 days to respond to that notice. Maybe the agency wants to dispute that factual basis. Maybe the agency has additional facts that might lead us to a different conclusion. And maybe the agency says, you know what, we've looked into this over the past 30 days, we think you're right, and here's what we're gonna do to fix it. As to your second question about whether the AG's office would check in periodically to ensure that that pattern or practice was being rectified and that plan that was agreed to was being followed. Yes, absolutely. And that's in fact why we put into the amendment in subsection 6 that the Attorney General's office can seek court enforcement of a plan that was agreed to by the agency. So let's say, for an example, The AG's office has notified a law enforcement agency A that they have an identified pattern of practice of unlawful policing. The AG's office and agency A work together to come up with a plan to rectify that pattern of practice. We published the report saying that this is the pattern of practice and this is the plan. If agency A does not follow through with that plan, even though the Attorney General's office has not filed a civil action in court to force them to come up with that plan, the Attorney General's office has the ability to go to the court and enforce the terms of that agreement. Because we want to make sure that just because an agency says that they will do something, that they actually will follow through. And of course, when working with many law enforcement agencies that we worked with on this bill, they were completely supportive because they too agree that agencies should be held to a high standard, and they absolutely welcome that standard and that accountability included in this amendment. So I hope that answers both of your questions.
Yeah. And Aaron, for the record, just so the record is clear, I think I mistakenly said the noise is before the investigation. It is after the investigation, pursuant to the bill here and the explanation that Jessica just gave. Thank you.
Thank you so much. It did.
Thank you. Before we take the next question, I'll note for the record, Assemblywoman Krasner and Assemblywoman Summers Armstrong are with us. They joined us, I think, right as the presentation was starting. So if, Madam Secretary, you could mark them present in some retroactive fashion to indicate that they were here for the presentation, I would appreciate that. So we'll continue on with questions. We'll go next to Vice Chair Wynn.
Thank you, and thank you for your presentation on this bill. I know a lot of work has gone into it, and I appreciate that as well. I like this bill. I have a little bit of concerns on Section 8. It just makes me feel a little like it seems a little broad. So I just have a couple of questions on that. A lot of this is dependent on whether or not the record's becoming public if the Attorney General decides to proceed. And I understand what your intent is, and I understand your integrity in this, but for those that potentially follow you, using people that may have preceded you as an example, what do you do if an AG, do the records become public if an AG decides that they're going to ignore these statutes or ignore these enforcements? Because a lot of them seem to, like you talked about just recently with the court, enforcing that. It's still at the direction of the Attorney General. And as an elected official, how does the public have the ability to access what you are investigating or what your agency and your elected position is doing? Does that make sense?
It does make sense. And that was a question that I think we received yesterday, mid-afternoon, from an interested party. And what I want to do is I'm looking at the screen here. Oh, there they are. They're the middle right on my screen here. I'm going to let them chime in on this, but I will say, as a general matter, investigative items are shielded from public scrutiny in any event during the course of an investigation. That's just part of the practice. It's one of the exceptions in the public records laws, and so that's at the outset something that I would want to mention. But let me go to Southern Nevada there and have them chime in real quick.
And if I could just follow up with one thing, because I think they could probably answer this question as well. If the complainant themselves wants to make it public, is it still protected, and is it still secretive, for lack of a better word, or is there ability for it to be open at that point?
Thank you, Assemblywoman Jessica Adair, for the record, or rather Vice Chair Jessica Adair, for the record. So to answer the second part of your question, yes, absolutely. Anyone who files a complaint with our office is able to make that complaint public. And that goes in any instance. When we receive a complaint in our office, that complaint, if it is being investigated and is subject to an active investigation, either criminal or civil, it is confidential throughout the investigation. At the conclusion of that investigation, however, it is not confidential anymore and is subject to public records requests, and we routinely disclose those complaints as subject to public records requests at the conclusion of an investigation. If there is some confidential information identifying personal information about a complainant, we usually redact that. But the complaint itself is the public record. And if someone wanted to disclose that they had filed a complaint, it's absolutely their right to do so. Routinely, when it's part of our practice, when someone submits a complaint to our office, they get a letter in response acknowledging receipt of that complaint. And then, of course, if a complainant is making a complaint that we do investigate, they will be contacted by an investigator and they will be walked through the investigative process. So they will know that their complaint is being investigated. In terms of confidentiality generally, in terms of this subsection, just because an item, a piece of information that is being used by this office is confidential in the course of our investigation does not mean that it isn't also a public record, if it is rightly a public record, at wherever agency it may be located. So if, for example, a policy manual at law enforcement agency A would normally be a public record, of course, anyone can file a public records request at that agency, and that agency would have a statutory responsibility to respond to that public records request and produce any documents that would normally be a public record. However, what we really want to do is ensure that the information that this office is collecting is treated confidential through the course of the investigation. So we are, number one, protecting the integrity of the investigation. And because anytime there is a discussion about an investigation in the public, it can have a very detrimental effect on the ability of our office to conduct an investigation. But also we expect that people who would like to disclose this information may include their own interactions with police. And what we don't want to do is have a chilling effect on civilians and on officers who wish to disclose this information, or the weaponizing of these investigations because people have ulterior motives. So that's why we felt that this confidentiality provision was incredibly important and also consistent with how investigations are currently conducted in law, as the Attorney General mentioned. I will say, though, that there are exemptions if someone wants to disclose that information, they can do so. And of course, a court or a federal agency, which is mentioned in the amendment. But I want to thank you for that question, because this is something that we discussed at length with stakeholders in the meeting. It is important provision that we need to balance the integrity of an investigation, but also the need to be transparent and accountable to the public.
Yeah, and Vice Chair Wynn, Aaron, for the record, I just want to follow up on 2 points. First of which is that it does have the ability for a court to disclose this, and it is not only at the direction or as an impetus from the AG's office. If someone files with the court and they want to get it opened or released, then this does not prevent them from doing that. I also want to say this. I forget what phrase Jessica just used, but I will use the word nefarious motives. There are some people with nefarious motives, and if we conduct an investigation and determine that there was no pattern of practice against, and that it involves a particular officer or a particular individual, civilian, there are folks who just want to sully somebody's name, and we need to be conscious of that as well. And so I think, again, in an effort to balance the protections and interests of the parties involved, especially in the instance where no violation has occurred and this is purely a nefarious sullying intent, we want to have protections in statute to disallow that.
Any other follow-ups, Vice Chair?
No, I'm good. Thank you so much. And I'm glad that we're having this conversation. I like this bill, and I'm glad that you're working with all the stakeholders to find that balance.
Thank you. We'll go for the next question to Assemblywoman Bilbray Axelrod.
Thank you, Mr. Chair. I apologize. I know you said it, Attorney General, but I missed it somehow. How many other states have this authority currently?
I did not say it, so you did not miss it, Assemblywoman. I anticipated the question, though. I think there are half a dozen right now that currently have it. but there are several others, including Illinois, for example, who are pursuing it. And in the interest of full disclosure, understand that my fellow attorneys general and I, several of us submitted a letter to Congress when they were first considering a draft of the George Floyd Justice and Policing Act, asking them to give us this authority via the federal statute as well. So there are efforts that are taking place all across the nation to afford state attorneys general offices to pursue this.
Thank you for that.
We'll take a question next from Assemblyman O'Neill.
Thank you, Mr. Chair. I had two questions, but Ms. Gonzalez jumped the gun on me. It's a great question, I thought. I want to say good morning to the General and to his staff. I appreciate the bill. I appreciate you really working with the number of stakeholders. To me, it enhanced the bill tremendously. The only question I have remaining is it's just a clarification. In investigations, does this bill, I mean, grand juries are a great tool. Does this bill give you the statutory authority to impanel or utilize grand juries? I don't read it in there, but I just wanted to make sure I understood it correctly.
This bill does not. We have statutory authority elsewhere to impanel grand juries for criminal prosecutions. Very seldom are grand juries impaneled for non-criminal items. Sometimes it's simply to get reports from jurisdictions and things of that sort. That's not what this contemplates. But let me turn to my team down south to see if the conversation came up in the context of conversation.
Thank you, Attorney General, and thank you for the question, Assemblyman Jessica Dare, for the record. It did not, and that is because this bill is limited to civil litigation, not prosecution of any one officer or group of officers who might be subject to an investigation. This is entirely civil in nature. The only purpose of this bill or any action brought by the AG's office would be to have a court determine whether or not there is a pattern of practice of unlawful policing at a particular agency and what the agency should do to change to become better. That is the only question that would be before the court. But it is important that you bring this up because it is worth reiterating that point and also reiterating that if in the course of an investigation with this office or in looking at a pattern of practice with an agency, this bill does not change an agency's ability and right to discipline any officer that may have broken policy. And it does not change the right and statutory jurisdiction of any city attorney or district attorney to bring a charge if a particular officer violated the law. So those agencies rightfully retain that jurisdiction. And I want to make that point very clear on the record because it is important that if there is a problem at a particular agency, that we have a variety of tools to address that.
Thank you, Mr. Chair. Thank you, General. Thank you for the time, Chair. I appreciate it.
You're very welcome. We'll go next to Assemblywoman Hanson.
Good morning. Thank you, Chair, for the opportunity. And it's good to see you, Attorney General Ford and staff. Actually, a couple of my questions might just be Law School 101 for a lay person like myself. But actually, I want to follow up on what Ms. Adair just expanded on to make sure I understand what exists now and just kind of what the bill's looking to maybe add upon. So now if an agency, and I'll just use some specifics, like say Sparks has a situation and Reno investigates them, because I think if I understand right, if there's a situation in question, you don't investigate yourself, you have another municipality investigate. So say Reno investigates, that's still allowed to go on. But if there were some other complaint or there's not a satisfaction with it, then you could be involved in the process. Am I understanding that right? Well,
with all due respect, Madam, no, ma'am, there are two different issues we're talking about here, Assemblywoman Hanson. The context in which I think you're speaking, for example, would relate to an officer involved use of force claim I won't mention cities. Let's say City A has an officer-involved shooting. City B may investigate City A or that shooting, not the department itself, but that shooting, because as you've indicated, that particular entity doesn't want to investigate itself. There are what we call memoranda of understanding that are operative throughout the state right now, and those types of things take place all the time. That's separate and apart and qualitatively different than what we're talking about here. We're not talking about the investigation of the shooting itself, for example, to see if a particular law enforcement officer violated policies and things of that sort. We're looking at patterns and practice of an agency. So, and right now, my understanding, to my knowledge, there does not exist an MOU that says that City B can go investigate City A on a pattern and practice level. They can do these one-offs. They can do the individual investigations, but they do not do the citywide, or pardon me, the department-wide investigations. That's what this bill would allow my agency to do. And that's the current ability that the federal government has to the extent they want to utilize that authority. But there is no city to city, as far as I know, and I'm looking down south to see if that conversation came up, but I think I'm right in that regard. So I hope I've helped to unconnect those two issues. They're just different. And so there's a follow-up, Assemblywoman Henson, I'm happy to address it.
Thank you. That helps greatly. I appreciate that. And yes, City A and City B. I stand corrected. Also, in Section 1, subsection 4, when you talk about civil injunctive only, no damages. Injunctive, just for us lay people, means, is it essentially when there's an injunction, kind of a cease and desist, like you need to stop what you're doing?
It could be a stop what you're doing. Oh, I almost started to rap. You know what I was about to say, right? Stop what you're doing because I'm about to ruin the image and I better stop because this is being filmed and I can guarantee you someone's going to put this up on Twitter somewhere. Vice Chair Wynn is shaking her head and I see she's going to be the culprit there. Anyway, it could be a stop what you're doing, or it could be start doing this as well, to the extent that's what it's. But yes, that's what injunctive relief is. Money, damages means money. So there's no lawsuit for money.
Hey, thank you so much. I appreciate the hard work you guys have all done with all those stakeholders, and appreciate you giving me an education today. Thank you.
Do we have additional questions from committee members? If so, if you could please raise your hand. I don't see any additional questions at the moment. So Attorney General and Attorney General Part B down in Las Vegas, we just ask you all to sit tight for a moment. We're going to go ahead and take some testimony on the bill, and then we'll come back for any concluding remarks. So at this time, I'm going to open it up for testimony in support of Assembly Bill 58. I believe we have a couple individuals, perhaps more with us on the Zoom, who'd like to testify in support. I see Mr. Pirro has his camera on. So Mr. Pirro, if you're intending to give supportive testimony, we'll start with you and then we'll go to Ms. Birchie. So please go ahead.
Thank you, Mr. Chairman. John Pirro for the record from the Clark County Public Defender's Office. I'd like to thank the Attorney General for bringing this bill forward and also for putting us all in a room for a very long time and working out all the aspects of various pieces of legislation that the Attorney General was bringing forward. We think that the process, the deliberative process that we all worked on together made the bill a better piece of legislation. And so we're grateful for his ability to bring us all together to work on issues and to make the best pieces of legislation put forward to the legislature. So we are in support.
Thank you for your testimony, Mr. Pirro. Ms. Birchie, would you like to go next?
Thank you, Chair Yeager. Kendra Birchie, for the record, with the Washoe County Public Defender's Office. I want to also thank the Attorney General Ford for this legislation, as well as, more importantly, for bringing us all together, as well as his team. I would just hope that with this legislation, we are able to provide our community members with some transparency and the assurance that there will be accountability. So we really appreciate his hard work in order to ensure that our citizens are protected. Thank you.
Thank you for your testimony, Ms. Birchie. Is there anybody else on the Zoom who'd like to give testimony in support of Assembly Bill 58? If so, if you could please turn on your camera, unmute yourself, and let me know. Doesn't look like that's happening. So BPS, let's go to the phone lines and see if there's anybody there who'd like to testify in support of Assembly Bill 58.
Good morning, Chair. To testify in support of Assembly Bill 58, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 556. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIE, GRANT. My brother Thomas Purdy was hogtied by Reno police and asphyxiated to death while hogtied and put prone by 4 deputies on his back, neck, and legs. I fully support this bill and only wish it was in place when my brother was killed by police 10/8/2015 in Reno, Nevada. I only wish it didn't take 5 years and for a man in another state to be asphyxiated to death by police for this bill to come before you all. Your state needs to own its own George Floyd's and shortcomings by law enforcement. My brother was killed at a time when the jail death rate of incarcerated loved ones was 5 times the national average at Washoe County Jail. Nito Smith and Justin Thompson were the 2 other asphyxiation deaths by deputies at the jail. The DOJ didn't act, and I can state that there was no one to investigation by Reno Police or Sparks Police. Nor do I believe there ever truly will be when they investigate themselves. Given Washoe DA Chris Hicks doesn't even review the deaths at the hands of police if the method of death is asphyxiation. This bill is needed. I'm not sure if the amendment still has notification requirements to the Attorney General within 72 hours, but it is stronger with it. Perhaps my brother's death wouldn't have been swept under the rug. No mention about my brother's death at the jail for over 2 years from the media. It took 13 plus people losing their lives at the jail for my brother's death to be made known to the public by someone other than myself. Injunctive relief is what our families truly want. True change in policy, true change in the laws. Money isn't going to bring our loved one back or save other people. Thank you.
Thank you for your testimony and support, Ms. Grant. BPS, let's take the next caller, please.
Okay. And the caller with the last 3 digits of 196, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Good morning, Chairman Yeager and members of the committee. I'm Eric Spratley, ERICSPRATLEY, the Executive Director of the Nevada Sheriffs and Chiefs Association. We signed in neutral, but with the amendment, we're here in support of Assembly Bill 58 and appreciate the Attorney General bringing this forward, as the law enforcement leaders in our association are not afraid of this kind of oversight and actually welcome the extra eyes that keep Nevada law enforcement agencies the best that they can be. The Nevada Sheriffs and Chiefs Association appreciates being a part of the conversation so that we arrive at consistency in conduct and equitability of enforcement in law enforcement agencies throughout the state. Thank you, Mr. Chairman.
Thank you for your testimony, Mr. Spratley. BPS, let's take the next caller in support, please.
With the caller with the last 3 digits of 014, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Good morning, Chair Yeager and members of the Assembly Judiciary Committee. My name is Ricky Gourier, RICKYGOURRIER of Tri-Strategies, representing the Nevada Police Union. We want to thank the Attorney General and his staff for bringing forth this important bill and working with the Nevada Police Union and other law enforcement across the state. Thank you.
Thank you for your testimony, Mr. Gourier. BPS, let's take the next caller in support.
Thank you, Chair. With the caller with the last 3 digits of 007, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good morning, Chairman Yeager, members of the committee, and General Ford. This is Attorney Lisa Rasmussen, RASMUSSEN. I'm testifying in support of the bill with the proposed amendments on behalf of NACJ. NACJ believes that this bill is good. It promotes accountability, and it provides a mechanism for addressing issues that the Attorney General has previously been unable to address. So we think that it's good. We ask that you support it.
Thank you for your testimony, Ms. Rasmussen. BPS, let's take the next caller in support, please.
With the caller with the last three digits of 130, slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINESAUNDERS, and I'm a policy director with the Progressive Leadership Alliance in Nevada. At Plan, we work to structurally transform Nevada's criminal justice system by organizing with people who have direct experience with mass incarceration and their families. We want to thank Attorney General for bringing this important bill forward to help increase police accountability in Nevada. After moments of police violence, we often hear the phrase, "It was just a few bad apples." However, the problems often continue to happen over and over again. Pattern and practice investigations are an important tool to address systemic racism and discrimination in law enforcement agencies. We urge your support. Thank you.
Thank you for your testimony, Ms. Saunders. BPS, let's take the next caller in support.
Thank you, Chair. With the caller with the last three digits of 695, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Good morning, Chair Yeager. This is Holly Wellborn, HOLLYWELBORN, Policy Director for the ACLU of Nevada, testifying in support of AB 58. We appreciate the Attorney General's office for bringing all stakeholders to the table and accepting our request to make the outcome of these investigations public after their conclusion. I do want to state that the effectiveness of this law depends on who occupies the Attorney General's office. Thus, the public has an interest in monitoring responsiveness to complaints. But as an organization, we believe the publication of an annual report with the outcome of the investigation balances that interest with a compelling need to monitor systemic racism in policing. Pattern and practice investigations have proven to be an effective tool to rein in and reform dysfunctional law enforcement agencies. We often hear that cases such as the George Floyd case and countless others is the result of a few bad actors. But pattern and practice investigations in cities like Chicago and others reveal deep systemic issues that perpetuate violence and disparate treatment of Black and Brown Americans. You will often hear us and other police reform advocates complain that we are passing police reform policies that have no teeth. While there's still much work to be done, this bill gives us a valuable tool to discover and weed out systemic issues in Nevada police departments and is responsive to community requests for Attorney General intervention. We appreciate Attorney General Ford for bringing this forward and for continuing to move us forward in ending racism and policing in Nevada. Thank you so much.
Thank you for your testimony, Ms. Wellborn. BPS, are there additional callers in support?
Yes, Chair. With the caller with the last three digits of 668, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Thank you, Chair Yeager and members of the committee. Good morning. My name is Troy Krumme, TroyceKrumme, and I am the Vice Chairman of the Las Vegas Police Managers and Supervisors Association, and we are members of the Public Safety Alliance of Nevada. We would like to thank the Attorney General's office for bringing the many of the stakeholders together to ensure many impacted voices are heard in crafting this bill. It is imperative in policing that the community know that their police departments are operating in a manner consistent with keeping them safe while at the same time building public trust. It is our belief to achieve this mission, the public needs to have an avenue and an agency to communicate with and work with an agency that have the authority to investigate and confirm that police departments are conducting themselves in a manner that the community should expect, or if it is found that the agency has a shortcoming, have the authority to bring upon corrective actions. With the proposed amendment language entered into this bill, we feel this bill hits the mark, and accordingly we support this bill. Thank you.
Thank you, Mr. Krumme. BPS, are there additional callers in support?
There are. We are currently taking testimony in support of Assembly Bill 58. To provide testimony, press star 9 now to take your place in the queue. Would the caller with the last 3 digits of 683 please slowly state and then spell your name for the record? You will have 2 minutes and may begin now. Caller with the last 3 digits of 683, press star 6 to unmute and begin your testimony.
Good morning, Mr. Chairman, Madam Vice Chair, members of the committee. My name is Rick McCann, R-I-C-K-M-C-C-A-N-N, Executive Director of the Nevada Association of Public Safety Officers and a member of the Nevada Law Enforcement Coalition. I'm here today in support of AB 58 as amended. This bill is part of a police reform movement that some feel should be opposed and denounced in their entirety by all law enforcement. But we recognize and embrace those efforts that seek to protect the public while at the same time not losing sight of the important and dangerous work being done every day by law enforcement throughout our state. Attorney General Ford and his staff have gone to great lengths to balance those interests, and we applaud those efforts. NAPSO was pleased to be part of a robust series of discussions with many stakeholders to come to the present bill as amended. Therefore, we support AB 58 as amended, and we encourage this committee to do the same. Thank you.
Thank you for your testimony, Mr. McCann. VPS, if there are additional callers in support, let's take the next one, please.
Thank you, Chair. Would the caller with the last 3 digits of 037 please slowly state and then spell your name for the record? You will have 2 minutes and may begin now.
Tanya Brown, T-O-N-J-A-B-R-O-W-N, Advocates for the Inmates and the Innocent. Thank you, Chairman Yeager. Thank you, Attorney General, for bringing this bill and your presentation. We support this bill, strongly support this bill. I just wish that this bill would have existed some years ago. I personally had filed a police report with the RPD. I personally spoke with the chief of police over some officers and some other situations that were involved with the complaint. We sat down, we spoke, and the chief of police at the time agreed what their officers had done. They were involved in it, but because of it being a conflict of interest, they could not do anything. So when I asked to have the Attorney General's office investigate the matter and for them to put in a request for the Attorney General's office, and even with the U.S. Justice Department, they refused. And this has been an ongoing problem over the years with people who want to file complaints against law enforcement officers and their agencies. They'll agree that there's something going on, but they won't take the next step or they won't do anything at all, period. And basically, they just cover it up. Almost 2 years ago, I filed another police complaint against some public officials. It went through the Reno PD, and it has never made it past intake. Now, the officer involved who took the complaint actually gave me a copy so I could submit it to the Attorney General's office, which I did do. And I have not heard anything. So I'm hoping that this bill will help in both areas. Thank you and have a good day.
Thank you for your testimony, Ms. Brown. BPS, let's take the next caller in support.
Thank you, Chair. Would the caller with the last 3 digits of 104 please slowly state and then spell your name for the record? You will have 2 minutes and may begin now. Caller with the last 3 digits of 104, press star 6 to unmute yourself and begin your testimony.
Good morning, members of the committee. My name is Maria Teresa Lieberman Parragas, MARIA-TERESA LIEBERMAN BERMANN-PARRAGA, and I'm here representing Battle Born Progress, and we are in strong support of this bill and thank the Attorney General for bringing this forward and doing all the work to create more transparency in our law enforcement practices. This is exactly what our communities have been asking for, and this is a very good first step, And instead of taking up more time, everyone has already mentioned where we stand, basically. So ditto to everything that everyone has said. Thank you for your time.
Thank you for your testimony, Ms. Lieberman-Paraga. BPS, if there are additional callers in support, let's take the next one, please.
To testify in support of Assembly Bill 58, press star 9 now to take your place in the queue. Chair, there are no more callers in support of the bill at this time.
Thank you, BPS. I will close testimony in support. I'll now open up for testimony in opposition. Don't believe we have anybody on the Zoom in opposition, but if I'm incorrect about that, please turn your camera on, unmute yourself, and let me know you'd like to testify in support. In opposition. I don't see that happening, so BPS, let's go to the phone lines and see if there's anybody there who'd like to testify in opposition.
To testify in opposition of Assembly Bill 58, press star 9 now to take your place in the queue. And we will start with caller 807. Caller 807, you have, please slowly state and then spell your name for the record. You have 2 minutes and may begin now. Caller with the last 3 digits of 807. Press star 6 now to unmute yourself and begin your testimony.
Good morning, everybody. My name is Richard Carpel. That's K-A-R-P-E-L. I'm the Executive Director of the Nevada Press Association. Although its aims are laudable, we take no position on the larger bill. However, we are concerned with Section 8, which makes all information collected during the investigatory process confidential when a civil suit isn't filed by the Attorney General's office. We do understand that there may be reasons to keep some of that information confidential, but there are already many statutory and common law exceptions to the Public Records Act that would allow the Attorney General's office to prevent the release of personal or other potentially harmful information. With those tools already in place, it doesn't make sense to us to throw a blanket of secrecy over the entire process. If there are specific types of records proponents believe should not be released to the public, but that are not considered confidential under current law, we think those specific narrow exceptions to the Public Records Act should be written into the bill rather than making everything secret. Thank you.
Thank you for your testimony, Mr. Carpel. BPS, are there additional callers in opposition?
Yes, would the caller with the last 3 digits of 122 please slowly state and spell your name for the record? You will have 2 minutes and may begin now.
My name is Benjamin Zenson Lipman, B-E-N-J-A-M-I-N, Z-E-N-S-E-N-L-I-P-M-A-N. Mr. Chairman, thank you. Madam Vice Chairwoman, I am here on behalf of the Nevada Open Government Coalition. And like the NPA before us, we do not take a position and are not here to speak in opposition to the basic premise of the bill, but rather oppose and are deeply concerned about the portions of the bill that, inadvertently or not, would shroud the system in secrecy. And we certainly appreciate the Vice Chairwoman's expression of concern on this issue as well. Investigations in the state of Nevada are not always closed, just as a matter of course. And that's for a good reason. That the public has a right to know and good reason to know what their governmental entities are doing. And victims have a right not to have their stories hidden from the public. Hiding allegations like these serves only to perpetuate the silence that has let these problems fester for years and, in fact, decades. Knowing that one person has the courage to come forward encourages others to come forward. We've seen time and time again in this state and across the country situations in which victims of abuse have come forward after they know that other victims have had the courage to step forward. There is some safety in numbers, and many of these problems would never have come to light. And in fact, even statutes like this would likely never have been proposed if there wasn't a public understanding and a demand for accountability that comes with the ability in the first instance of the public to know that these allegations are being made. And allowing public to see this information assures accountability for those conducting the investigations as well. We are not expressing concerns, of course, about Attorney General Ford. His efforts to bring this statute are laudable, but whether it's this administration or ones to come, we have to have accountability by the public. And the only way we can have that is if the public knows what the Attorney General has done in these investigations, and not simply know when the Attorney General chooses to bring a lawsuit, but when the investigators choose not to take any action. The public needs to know what the allegations were so that the public can decide for itself whether there should have been action when none is taken. The confidentiality provisions in this bill are extremely broad. We do not think that there should be the confidentiality, or if there is, only for a limited time and only for very specific information. We have to remember that as the Attorney General has said, it is the agency that is being investigated here. And certainly it should never be the case that allegations against a government agency, whether well-founded or not, but allegations against a government agency should ever be shrouded in secrecy. And for that reason, we oppose the confidentiality provisions in this bill. Thank you.
Thank you for your testimony, Mr. Zenson-Littman. BPS, are there additional callers in opposition?
Yes, Chair, there are. Would the caller with the last three digits of 883 press star 6 to unmute yourself and then slowly state and spell your name for the record? You will have 2 minutes and may begin now.
Thank you, Chairman Yeager and members of the committee. My name is Alina Schell. It's ALINA-SHELL. And I am a civil rights attorney at McCletchy Law in Las Vegas, Nevada. I find myself in an odd position today because in spirit, I support enabling the Attorney General to investigate law enforcement agencies accused of engaging in a pattern and practice of civil rights violations. But I cannot support the bill as currently drafted because of the overbreadth of the confidentiality provision. Now, I appreciate the desire of the Attorney General and the other stakeholders on this bill to protect whistleblowers and witnesses, but as currently drafted, the bill actually impacts the interests of civil rights litigants. Civil rights lawsuits are the most long-standing and prevalent way to address patterns and practices of civil rights abuses. To steal a phrase from Attorney General Ford, civil rights lawsuits are one of the most important tools in the civil rights reform toolbox. I have litigated issues concerning policing issues concerning race, and in civil rights cases against a police department, the fact that the state has investigated whether a department is engaged in a pattern and practice of civil rights abuses, regardless of the outcome of that investigation, would be immensely important to civil rights cases. And again, I appreciate the desire and the need to protect whistleblowers and witnesses, But there are alternative methods to protect those individuals that would not require the sort of wholesale sealing of all of the testimony, the documents, the investigation, and evidence, either as the bill was initially introduced or with the Attorney General's proposed amendments. It's ironic to me that confidentiality has historically hindered federal civil rights investigations as well as civil rights litigation. And it seems to me that the provision as currently drafted would do exactly that. It would hinder things by covering it in a blanket of confidentiality. And I just wanted to also note to the committee that it's important when assessing this confidentiality provision to consider the mandates of the Nevada Public Records Act. That democratic principles are best served by broad access to public records with only narrow confidentiality exceptions. Transparency regarding these sorts of investigations not only promotes public trust in the Attorney General by allowing the access, by allowing the public access to assess how well the Attorney General is carrying out the law, it would also promote public trust in the police. And I thank the chairman and the committee for your time.
Thank you for your testimony, Ms. Schell. BPS, if there are additional callers in opposition, let's take the next one, please.
Thank you, Chair. With the caller with the last three digits of 976, press *6 to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes and may begin now.
This is Scott Nicholas from the Las Vegas Police Protective Association, Vice President, SCOTT-NICHOLAS. We oppose this bill for several reasons. One, there's been 0 cases, as the AG has already pointed out, that have come to light in any recent memory for this bill to need to investigate, or this office to investigate. The DOJ already has the ability to investigate the departments. So again, duplicated services. The departments are doing a great job, and that's why we have 0 cases in this state, because they have the ability to investigate and do a thorough investigation. They've been doing a great job with that, especially here at LVMPD. The next reason is that the bill would cause resources to be impacted severely that are in place right now. And if they aren't impacted, that means that there's going to be a large fiscal and costly impact to the state taxpayers. So for these reasons, we don't believe this bill is necessary. It really looks like it's another political move just to satisfy groups that believe that there's some type of misconduct that clearly isn't there. So thank you.
Thank you, Mr. Nicholas, and I will caution callers to please limit your comments to the substance of the bill. We're not here to question the motives of a sponsor of legislation. We're here to vet whether the policy in front of us is good or not. BPS, if there are additional callers in opposition, let's take the next one, please.
To testify in opposition of Assembly Bill 58, press *9 now to take your place in the queue. Chair, there are no more callers in opposition to Bill 58 at this time.
Thank you, BPS. I will close the testimony in opposition. I will now open it up for testimony in neutral. Do we have anybody on the Zoom with us who'd like to testify in neutral? If so, if you could please turn your camera on, unmute, and let me know. Okay, I don't see anything happening on the Zoom. BPS, could we go to the phone lines to see if there's anybody there who'd like to give neutral testimony?
To provide neutral testimony on Assembly Bill 58, press *9 now to take your place in the queue. Chair, there aren't any callers who wish to provide neutral testimony to Bill 58 at this time.
Thank you, BPS. I will close neutral testimony. I'll now invite back to the virtual table Attorney General Ford and the rest of his team in Las Vegas. Attorney General will give you and your team the last word on Assembly Bill 58.
Thank you, Chair. Aaron Ford for the record, your Attorney General. I have a few responses to some of the comments made, but I do want to offer my Chief of Staff, Jessica Adair, a few comments on the confidentiality provision, and then I will like to speak on that as well. Go ahead, Jessica.
Thank you, Jessica Adair for the record. I want to specifically address some of the comments made about subsection 8, the confidentiality provision of this amendment, because I think that there is some misunderstanding and confusion that may lead to some opposition that led to some of this opposition testimony. There was a statement that civil rights litigants would be in a worse position because of this provision. I would argue that is a misunderstanding of this provision. Subsection 8 of this bill does not change any of the existing statutory responsibilities that lay on any law enforcement agency that currently exists in the Nevada Public Records Act. If law enforcement agency A has documents that are subject to public records disclosures, whether or not those documents are used by our office in investigation does not change that agency's responsibility to respond appropriately to public records requests. Additionally, it does not change the normal process for litigation discovery if an individual was to file a civil rights lawsuit against an agency or against a law enforcement officer. All of the normal processes that occur for litigation discovery would still be in effect. So civil rights litigants would be in the exact same position that they are in right now in the state of play here in Nevada. This bill would not change that. Additionally, a caller noted that the public needs to know what the allegations were that led to an investigation, whether or not the AG's office filed a civil action. And you're right, and that is why we included that in subsection 7 that specifically requires the AG's office to publicly disclose the existence of an investigation and the conclusion of that investigation, whether there was an identified pattern of practice or not, or if there could have been a pattern of practice, but the factual basis was not substantiated. That is why we've included that section, subsection 7, and that was at the specific request of some groups who have a vested interest in transparency and open government. I would have encouraged these folks to come to our office and discuss these concerns with us, and we're happy to do that in the future as soon as we leave here to maybe clarify some misunderstanding in that regard. I would also state that complaints made to our office are subject to public records disclosure. In addition, so in terms of the allegations made, yes, that those would be subject to the Public Records Act in the normal course of a public records request to our office. I hope that clears up some of the confusion that was brought to light in the opposition testimony.
And thank you again, Mr. Chair. Aaron Ford for the record. And I also want to highlight the fact that it is not a blanket confidentiality provision. The statute, the law itself says that it can be disclosed if authorized by a district court. So this isn't a blanket confidentiality provision, to be clear. And I'll also say this, we didn't hear about the concerns until yesterday, unfortunately. The language has been out since November. We have had working groups ongoing for months, including a humongous one last week, and it would have been great. And in fact, some of the members of the Open Governments Coalition were a part of the discussion group. So this bill has intended to incorporate a lot of those concerns. That said, we're happy to, as Ms. Adair said, disabuse folks of any misconceptions or misunderstandings around the bill. And that leads me to another couple of points. We did invite the PPA to participate in the discussion on this issue. They neither responded, they didn't respond, didn't show up to the meeting. And it's unfortunate that they have shown up today in opposition. We asked them to submit to us language for consideration if they had any suggestions, and this was months back, and it has not taken place. And so it's unfortunate to hear them oppose, especially when we have other comparable labor unions in favor of this because they participated in the process. I will also say this to the point, if you will indulge me, Mr. Chair, there was an allegation that this was political. It is not political. It's policy. And frankly, it's also a little personal. The truth is, I have done ride-alongs with law enforcement recently in Elko, and I have seen and appreciate the day-to-day interactions that our law enforcement have to engage in. I get a day in their life. The truth is, Mr. Yeager, they can't walk a second in my shoes as a black man. And having to respond in the aftermath of George Floyd, there's no ride-along that I can offer them. What I can offer them is what we did offer, which is to come sit at the table with us, to hear what we're having to say around these issues. Let's figure out a way to accommodate the interest of our community, which is demanding better relations and more trust in law enforcement. And I'm a member of it, whether they like it or not. And what I've endeavored to do here through my justice and injustice forums, through dozens of conversations, and through the work of this working group is to come up with a bill that accommodates the interests and concerns of all parties interested. And if you will allow me a little vulnerability, I will tell you, this is not easy. The people who sat in that room last Tuesday and hashed this out on both sides, on all sides of this issue, they did this. And I'm immensely grateful to them for coming together, understanding the importance of this moment and figuring this out. They did this, and it wasn't easy. I said, I'm not on the ACLU side. I'm not on the DA side. I'm on the side of justice. In our office, we say our job is justice. And this bill helps to effectuate justice in our state. And so to the extent those who are opposing have misunderstandings or misconceptions around this bill, we invite you to come talk to us. Happy to hear what you have to say and to try to disabuse you of those notions. And we would also ask going forward that you engage us before the night before. So that we can see if there are other things that can be done to address your concerns. And the last thing I'll say is on a bright note, Mr. Yeager, unless you have additional questions for me, and that is, I am prone to do a little karaoke here and there. It seems like I may need to add Humpty Dance to my repertoire in addition to Brick House and a Nothing But a G Thing, the clean version, of course. And so thank y'all so much for engaging me in this conversation today. I certainly hope that we can have your support in what has been a great bipartisan effort, a multi-party effort, and I have a lot of gratitude to my team down there in Southern Nevada for pulling this off and putting folks in the same room, and for those who got into that room to work this out. You are appreciated, as Tupac would say. So thank you so much, Chair Yeager.
Thank you, Attorney General Ford, Ms. Adair, and the rest of the staff who helped present this morning. Certainly appreciate it. And again, just want to thank those who did engage. I know this bill was a lot of work and a long time coming, so I appreciate that as well. And thank you all for joining us here this morning, and we hope you have a really great rest of the day.
All right, bye-bye.
So with that, I'm going to close the hearing on Assembly Bill 58. Committee, we're going to move on to our second bill on the agenda. I will now open the hearing on Assembly Bill 251. Assembly Bill 251 makes various changes relating to juvenile justice. We have our own Assemblywoman Krasner to present the bill this morning. And before I hand it over to her, I will let members know and members of the public know that there is an amendment to the bill that can be found on Nellis under the exhibit tab, and I believe Assemblywoman Krasner and her co-presenters will go over that with us. So Assemblywoman Krasner, welcome. I think this is the first time you're presenting in Assembly Judiciary, this committee, this session. It's a pleasure to have you, and please proceed.
Thank you, Chairman Yeager. For the record, I am Nevada State Assemblywoman Lisa Krasner, representing Nevada State Assembly District 26. I am pleased to present Assembly Bill 251 for your consideration today. AB 251 will help to make sure that a child under age 18 does not waive their Fifth Amendment constitutional rights without first talking to a parent, a guardian, or an attorney. Assembly Bill 251 will also help address the harsh impact that a child's juvenile record might have on their future success in society. We always talk about giving kids a second chance or a fresh start, but we never really seem to give them one. AB 251 does three things, and we are working off of the amendment. First of all, AB 251 requires a police officer or probation officer to ensure that a child in custody first consults with the parent, guardian, or attorney before waiving their Fifth Amendment constitutional right to Miranda and the custodial interrogation of the child begins. Second, Assembly Bill 251 also establishes provisions for a juvenile's records to be automatically sealed at age 18 years old. Currently in Nevada law, juvenile records are automatically sealed at age 21 years old. Third, AB 251 allows someone over the age of 18 to petition the court for the expungement or destruction of their juvenile records for any infraction, arrest, or crime that was committed as a child and was equal to a misdemeanor or less. Some background information. The landmark 1967 United States Supreme Court case in re Galt involved a 15-year-old boy sentenced by a juvenile court to serve 6 years in state industrial school for making a prank phone call. Overturning the lower court's decision, the court held that children facing prosecution in juvenile court have the same due process rights as adults, including the right to remain silent, the right to notice of the charges against them, the right to an attorney, and the right to a full hearing of the merits on the case. A more recent case also involved due process. JDB versus North Carolina. JDB was a 13-year-old student enrolled in special education classes who police suspected of committing a crime. JDB was interrogated by his school by a uniformed investigating police officer and school officials. He subsequently confessed to stealing and was convicted. JDB was not given his Miranda warnings during the interrogation, nor an opportunity to contact his parent or his legal guardian. Attempts to suppress the statements given by JDB because he was not given his Fifth Amendment rights to Miranda were denied on the grounds that JDB was not in police custody. After hearing the case on appeal, the United States Supreme Court held that age and mental status are relevant when determining police custody for Fifth Amendment Miranda purposes. Even after these cases, gaps remain in state procedural due process protections for kids. For example, in many states, lawyers are still not guaranteed for every child during a police interrogation. As this committee has heard in other testimony, a child's brain is not fully developed until age 22, and they are not able to make logical, well-informed decisions, especially under a stressful situation, such as a custodial interrogation. We don't let kids buy alcohol until they reach 21 years of age. But in Nevada, we let kids waive their constitutional right at age 15, 16, 17. According to the National Conference of State Legislators, several additional states have begun to address this matter, at least regarding the Fifth Amendment constitutional rights under Miranda. Recently, 2 states enacted laws increasing due process protections for our young people when they are being interrogated by police. In California, they now provide that all youth under age 21 have the right to consult with an attorney prior to a custodial interrogation by law enforcement. Virginia now gives a young person the right to have contact with their parent, guardian, or an attorney, either in person, by telephone, or by video conference before a police interrogation. Turning to the topic of juvenile records, one commonly held misconception is that once a child turns 18, their juvenile record disappears and they can go forth with a clean slate. In many instances, that is not the case, and young offenders may face serious consequences and obstacles as a result of their juvenile record. A juvenile adjudication can prevent a young person from receiving financial aid for higher education, admissions to college, getting a job, joining the military, or being admitted into certain licensed professions. It can also affect eligibility for public housing, not only for the delinquent minor, but also for his or her family as well. In the last 15 years, many state legislators have included provisions in their juvenile justice statutes to seal, expunge, and implement other confidentiality safeguards for juvenile records. As most of you know, sealing refers to closing records to the public, but keeping them open and accessible to court personnel and to law enforcement. In general, the child's record remains accessible to law enforcement officers and to prosecutors and sentencing judges for purposes of investigating and prosecuting any future crimes in which the youth may be involved. Expungement, on the other hand, involves the complete physical destruction of a juvenile record. All references to the juvenile's arrest, detention, adjudication, disposition, and probation must be deleted from the files of the court. Law enforcement and any other person or agency that provided services to a child under court order. An expunged record is to be treated as though it never happened. All states have some sort of procedures that allow juveniles to petition to either seal or expunge their records in certain cases. However, these procedures can be confusing and cumbersome, and it is high time we address this confusion. In addition, the United States Supreme Court cases, including JDB versus North Carolina, require us to take a hard look at our juvenile justice statutes and practices that have been in place for many decades. Our next step as a state is to update our treatment of juvenile records and to conform the laws that are shaping the juvenile justice system to what the United States Supreme Court has now mandated in terms of how we treat children. Sections of the bill. So we are working off of the amendment in the bill found in the exhibit section in AB 251 on Nellis. Assembly Bill 251 contains 3 components. First, the first of these provides that prior to a custodial interrogation, a peace officer or probation officer must ensure that a child in custody is able to consult with a parent, a guardian, or an attorney before consent to waive their Fifth Amendment constitutional right to Miranda. That can be in person, via teleconference, or over the telephone. The second component of the bill addresses the sealing of records. Currently, in Nevada law, there is automatic sealing of juvenile records at age 21. This bill would change automatic sealing of juvenile records to age 18. There would still be judicial review in some cases. That will remain the same. The third component of the bill states that after age 18, a youth may petition the court for the expungement or destruction of all juvenile records for infractions, arrests, or crimes committed as a juvenile that were a misdemeanor or less when committed. In conclusion, now is the time to address the inequities in the law as it relates to children being able to waive their Fifth Amendment constitutional right to Miranda, and to address the impact that a child's juvenile records can have upon a child's life, a child's future. The United States Constitution starts with 3 words: we the people. And who are these people that our founding fathers talked about? They're you and you. They're me. They're us. We are the people who make the law in this state. We are the people who can really give our kids a fresh start or a second chance. Please join me in supporting AB 251. Next, you will hear from the co-presenter of AB 251, Ms. Kendra Birchie. from the Washoe County Public Defender's Office. After Ms. Burgie's testimony, we are happy to answer any questions. Thank you.
Thank you, Assemblywoman. Appreciate the presentation. Ms. Burchie, if you want to go ahead and make your remarks, and then we'll have a chance for questions.
Thank you, Chair Yeager. Thank you, Assemblywoman Krasner, for bringing forward this extremely important bill to help fill those gaps to ensure that our children are protected. The American Bar Association reports that juveniles waive the Miranda rights at extremely high rates, with several studies putting it at roughly 90%. Studies including the University of Michigan Law School exonerations in the United States have shown that a staggering 42% of exonerated juveniles had falsely confessed. 42%. One child that is wrongfully convicted is one too many. As you heard from Assemblywoman Krasner, states across the nation are working to enact laws to protect our children from wrongful convictions by adding additional protections to juveniles when they are interrogated. That includes Illinois, California, and a dozen additional states who are ensuring that either an attorney is present or a parent or guardian to ensure that these children understand their rights when they're deciding whether or not to speak with law enforcement. Subsection 1 in Section 1 of the bill in the conceptual amendment sets forth the requirement that there is a ban on police custodial interrogations of any youth under the age of 18 unless they've had that ability to consult with an adult, a parent or guardian or attorney about their rights. Below that paragraph in the conceptual amendment discusses the exact safeguards that this legislature should put into place in order to ensure that a child understands their rights, as well as the procedure for ensuring that police have contacted the guardian and that the child has had an opportunity to speak with that individual to understand their rights, and then to make that crucial determination as to whether or not to proceed with the interrogation. Regarding the safeguards, the first issue is whether or not when the police speak with the child, whether or not that they would like to speak with their attorney, a parent, or a guardian. In my prior practice, this element itself has been crucial because it requires for the police officers to indicate that not only would an attorney be appointed, but that's a free attorney. The reason why that is extremely important is a lot of children and even adults don't understand what appointment of attorney means. And so this clarifies that it is a free attorney who would be available to them right then. In the second part of that paragraph, it discusses what it means to waive your constitutional rights. And it provides not only the child with that opportunity to specifically state that they want to waive the right, but then also that parent or guardian to also state that they wish for that individual to waive their right. The Human Rights Watch states that this is additionally a very important thing for juveniles to understand, because a lot of juveniles think of when you say the right to remain silent, that means that you have the right to remain calm, which certainly isn't the case. So this is crucial to ensuring that all of the parties understand what is happening, and that when the juvenile does speak with law enforcement, that everyone is on the same page that it is necessary and that they wish to do so. This new law will ensure that no child is left to figure out their options alone when facing the prospect of interrogation. It will enhance the child's understanding, ability to exercise this vital constitutional right, and reduce the coercive pressures. It will hopefully mean fewer false confessions and fewer wrongful convictions in our state. And Chair Yeager, with that, we are open and available for questions. Thank you.
Thank you so much, Ms. Burchie and Assemblywoman Krasner, for your presentation of Assembly Bill 251. I'm going to start with a question from Assemblywoman Gonzalez.
Hello, good morning. Thank you so much, Assemblywoman Gonzalez, District 16 for the record. Thank you so much for presenting this bill and bringing it forward. I just had a few questions. So in the amendment, the first sentence where it says having consult an attorney parent or legal guardian, is that to consult all of those parties? Is it if they've consulted one of those parties, they're good to go? The word "or" is just throwing me off there. So can I just get some clarification on that? And then I also have a follow-up in regards to the questions in the paragraph in the amendment.
Yes. Thank you for your question, Assemblywoman Gonzalez. Assemblywoman Lisa Krasner, for the record. We are working off the amendment posted in Nellis. In section 1 of the amendment, in the bold area, it does say that a child may consult with an attorney, a parent, or a legal guardian. So any of those.
Thank you.
Chair Yeager.
Go ahead.
Assemblywoman Gonzalez, just to provide further information regarding that question. As public defenders, our stance would and request would be for the attorney to be involved. However, in negotiation.
Ms. Birchie, could you just state your name for the record, please?
I apologize. Kendra Birchie with the Washoe County Public Defender's Office. Just by way of context, in negotiating this bill and in negotiating this topic during the last session, this was one of the issues that was raised with the stakeholders, including the district attorney's office and law enforcement, that it should be an or of that. It should be an attorney or a legal guardian or parent.
Thank you so much. And then my follow-up question, well, is kind of two. So there are quotations in here of a scenario, right? So like, did you have enough time to speak with your parent or a legal guardian? You can have more time if you need. Do you want to waive your constitutional rights and speak to me? You can say no. Do you give consent to the minor to speak to law enforcement? So is this what's going to be in statute, and is this what is going to be required of the officer to say? And if it's not, then where in this are the officers going to be trained onto having this conversation with them? Thank you.
Thank you, Ms. Gonzalez. Assemblywoman Lisa Krasner, for the record. The Public Defender's Office prepared this specific language. I believe that this is the language that we do, in fact, want in statute, because it's so important that a child's constitutional rights are taken into account. I mean, I know you're all familiar with the case of Miranda versus Arizona, where a rapist was denied his constitutional rights as an adult and was eventually set free, according to our United States Supreme Court. We just think that a child should have the same rights to have their Fifth Amendment constitutional right of Miranda given to them and consult with a parent, guardian, or attorney before they're able to waive their constitutional rights.
And if I may, Chair Yeager, John Puro from the Clark County Public Defender's Office. Assemblywoman Gonzalez, all police officers, and for those that don't know, I know Mr. Assemblyman O'Neill knows, all police officers carry around a Miranda card in their pocket, and they generally read from that card. There was a case from the Federal District Court of Nevada that determined that the current Miranda usage that they were using at the time was inadequate. And Metro quickly corrected that and put it in their police reports. We are using this updated version of Miranda. When we read police reports, very often police officers will go through the Miranda warnings in the report that they went through with a client, so that we all know on the backside whether they were adequate. We'll also be able to view that on body cam as well. But this is the version that we'd like them to use with juveniles in statute and placed on their cards.
Thank you so much. Definitely answered my question. Thank you.
Take a question next from Assemblyman Wheeler.
Thank you, Mr. Chairman. Assemblywoman, what I'm reading here and what I have a question on is the definition of custodial. I know there's been many different, definitions of this, and it's still kind of vague in law a little bit here and there. But what I'm wondering about is unintentional utterances. For instance, a police officer pulls up in a shopping district and sees this huge broken window, and little 12-year-old Steve is standing in front of it, and he walks up to little 12-year-old Steve and says, "What happened here?" And he says, "Well, I didn't do it." And he says, "Well, do you know what happened?" He goes, "Yeah, I saw PK swing a bat and it slipped out of his hand, went through the window." So that's an unintentional utterance, I believe, is what it's called, or an utterance. Would that no longer be admissible?
Assemblywoman Wheeler, I'm going to let the Public Defender's Office answer that question.
I realize we're into gender neutral, but I prefer Assemblyman.
Chairman Yeager, to Assemblyman Wheeler, John Pirro from the Clark County Public Defender's Office. Assemblyman Wheeler, I do agree with you that the definition of custodial is something that is litigated often. I do not believe that this law would change it any more or make it any harder to litigate. When a person is not free to leave, we consider that under custodial interrogation. However, excited utterances are generally not excluded prior to Miranda under current case law.
Okay, generally, but it's not actually in current case law, is it? You would know more than I.
John Pirro, for the record, from the Clark County Public Defender's Office. They are generally not, but it is an issue that does get litigated, right? So if I was defending Assemblyman O'Neill, I would be litigating that issue. There is a likelihood that I would lose that issue, though, but I would still litigate it to protect his rights.
Okay, thank you.
And if I may, Chair Yeager, Kendra Birchie for the record, just Assemblyman Wheeler, just to also respond to your question, in the text of the introduced bill, which I believe would still be included in conceptual amendment, is the definition of custodial interrogation, where I believe it does specify that the individual needs to be detained. And so that wouldn't, unfortunately, Mr. Assemblyman PK O'Neill would not then qualify for having this law apply to him.
Thank you very much.
And I am
attorneys.
I am trying to confirm with my mother whether I did in fact break any windows when I was 12. I don't think I did, but I will let you know when she gets back to me. In terms of further questions, the list I have right now is Vice Chair Wynn, Assemblywoman Kasama, and then Assemblywoman Summers Armstrong. Is there anybody else that has a question? I see we have Assemblyman O'Neill, so I'm going to add him to the list. Anyone else out there with questions at the moment? Okay, I think we are good for now, so we'll go next to Vice Chair Wynn.
Thank you, Chair. I'm not sure who can answer this question. I was looking at the proposed amendments that we received that are on Nellis, and I'm looking at number 3, and it talks specifically about expungement. Do we have expungement statute, like provisions in statute, or do we only have sealing right now? And would this necessitate having an entire section dedicated to expungement as opposed to sealing?
Thank you, Chair Wynn, Vice Chair Wynn. Assemblywoman Lisa Krasner for the record. Yes, Section 3 of the amendment would allow an 18-year-old to petition the court for expungement. Currently in Nevada, we only have sealing. And now whether that would necessitate creating or writing a new section in the NRS, I would assume it would, but I'll let the Public Defender's Office respond to that.
John Pirro. Go ahead, Kendra. John Pirro, for the record. Assemblywoman Krasner is right that currently we only have sealing, but this may be a question best suited for legal in this case. I would say that Assemblywoman Krasner is going for the gusto because she wants to give kids a fresh chance at life, and we fully stand behind that.
Thank you. And I'll reach out to legal, and if they have any other potential details on how we can implement that, I will let the other committee members know.
Thank you, Vice Chair. And I wanted to let you all know that according to my mother who texted me, she doesn't think I broke any windows, but she also said that my My two brothers and I probably have done things in life that she is not aware of. So there's a possibility, Assemblyman Wheeler, that your analogy there might have actually happened some years ago. I'll try to get confirmation on that.
We have body cam footage, Mr. Chairman.
Good point. So we have a few more questions. We'll go next to Assemblywoman Kasama.
Thank you, Chair. Assemblywoman Heidi Kasama, Assembly District 2, Assemblywoman Krasner. I have a question, just kind of an overall question. So this is reducing it to age 18, and currently in statute it was 21. What was the original thinking between 21 and 18? Did law enforcement feel that they needed access to records for more years after somebody turned 18, or what was kind of the concept behind that?
Assemblywoman Lisa Krasner, for the record. Thank you, Assemblywoman Kasama, for your question. She's referring to the amendment, Section 2, where currently in Nevada law, a juvenile's records are automatically sealed at 21. This bill would bring that to 18, except for certain records that the court retains jurisdiction over. Those would still remain under the court's jurisdiction. The court would still have judicial discretion over those, just like it does now. I don't know what the original thinking was, because right now, a lot of kids, when they're 18, want to apply to college. And currently, all college applications are online. There's a question that you receive in the applications from the other 49 states, not Nevada. And that question is, have you ever been arrested? It doesn't provide a section where you explain that it was a bad arrest or anything like that. It just says yes or no. You can see where a child clicks the box yes. Because it's so competitive now to get into college, you can imagine that that application goes straight in the trash can. Thank you.
So we don't really know why we had 21. I understand the intent of the bill to make it 18, so it's better for children. I was just wondering if there was some law enforcement reason I don't know about why it was originally 21.
I'll let the Public Defender's Office respond. Maybe they have an answer for you.
Kendra Birchie, for the record, through you, Chair Yeager, to Assemblywoman Kasama. What we found really interesting is we actually had this conversation with the courts regarding a bill that you'll be seeing coming over from the Senate Judiciary and Senate Bill 7. What we learned is really no one knows why 21 was selected. And we've had these conversations that perhaps it should be at 18. And so I'm very grateful that as Assemblywoman Krasner is bringing this in order to have it more in line with our other statutes where a child is now an adult at age 18.
Thank you. And Chair, may I be indulged with another question?
Yes, please go ahead.
So explain to me from a layman's term, what is the difference between sealing and expungement? I know definitionally the record is still there in expungement, they're completely destroyed, but from a law enforcement standpoint, if it's sealed, does it mean that some courts could eventually still have access to it? Is that the current ruling for a sealed record versus expungement, which means it's completely destroyed? And would some courts still perhaps need access? So is it better to keep it sealed versus expunged?
Assemblywoman Lisa Krasner, for the record. Thank you for your question, Assemblywoman Kasama. Sealing refers to closing records to the public, but keeping them accessible to court personnel and law enforcement. Expungement, on the other hand, involves the complete physical destruction of a juvenile record as if it never existed.
And would law enforcement still perhaps need access? Is it better to keep it sealed versus expunged?
I can't comment on what law enforcement would say. You'll have to ask them.
And Kendra Birchie, for the record, if I may, Chair Yeager, through you to Assemblywoman Kasama, I believe that's the reason why Assemblywoman Krasner has specified that it would be for certain misdemeanor offenses, so that it's not for felony offenses or anything of that nature. So it's really the small minor offenses.
So expungement is strictly for misdemeanors or less?
Kendra Birchie, for the record, yes.
Thank you.
And John Puro, for the record, just to add a certain level of comfort as well, Assemblywoman Kasama, there are certain things that cannot be sealed, like sexual offenses, things that we want to keep track of to make sure that something like that never happens again. That's not going to be sealed under this legislation.
And the way that I read the proposed amendment, it looks like the expungement would be accomplished by filing a petition with the court. So I take it that there would be court involvement in deciding whether the record should be expunged. But, as we get to testimony on this bill, I certainly would invite anyone who's offering testimony who has a perspective on Assemblywoman Kasama's questions to offer that perspective when you provide your testimony. And we'll see. We have a number of folks who are still on the phone line, so we'll see who's going to actually testify on the bill, and they may have some of that information that you're looking for, Assemblywoman Kasama. A couple more questions before we move along. We'll go next to Assemblywoman Summers Armstrong.
Thank you, Chair Yeager. Chandra Summers Armstrong, Assembly District 6. Thank you, Assemblywoman Krasner, for your bill. And I'm very excited to see this. And I just have a clarifying question, and I'm sure that the public defenders could possibly help with, because I'm not quite sure about the difference between a custodial investigation or custodial and, where's the line drawn between if a young person or any person for that matter is being questioned, and when it becomes custodial where Miranda needs to be read. If you could kind of clarify that. And I do have one follow-up after that, Chair, please.
Assemblywoman Lisa Krasner, for the record, I will let the Public Defender's Office answer that question.
And John Puro, for the record, Assemblywoman Summers Armstrong, that's always going to be issue litigation. For us, from our standpoint, the moment a child is not free to leave, not free to walk away, that's custodial. I know the state may have a different position than us, but that's our position on that. The moment you are not free to walk away, not free to not answer questions that are being asked for you, that is the precise moment before any further questioning occurs that your Miranda rights need to be read to you. And I just want to let the committee know as well, because I didn't say this, our office is willing to take the step that we haven't taken before in the past to, if this legislation gets passed, we will be available by phone. We will have a phone line available, and attorneys will be on deck to answer the phone when something like this happens.
And Kendra Birchie, for the record, I'll just echo that we are also doing the same with our office. And I can note that the Department of Indigent Defense Services, they are responsible for the rural jurisdictions in order to ensure that policies and procedures are put into place. And so it's my understanding that they would be responsible to ensuring that for the rural jurisdictions as well.
Thank you, Chair Yeager. If I might ask the follow-up question.
Yes, please go ahead.
Thank you, because that was my next concern, and that is we've heard previously in a previous bill that wanted to have an attorney that child know that they can, or the person know that they can call and speak with an attorney. And I think that sometimes we look at these things from our perspective because we might have some more knowledge and have worked in environments that give us some insight. And I was sitting here listening to all this conversation, and I could just see in my mind a situation where a young person may have called their mom or dad or grandma and said, I'm going to be taken down, I don't know what to do. And then grandma or mom or dad would say, I don't know what you should do either. Maybe you better call. What about an attorney? Is that allowed then that child would be able to have a follow-up to then ask for an attorney? Or is that one phone call to the custodial parent or guardian and they have to make a decision right on the spot then? Or are they allowed that agency to say, maybe mom and dad can't answer for me or help me, I need to call an attorney and get some assistance? So if someone could speak to that, just regular people stuff. Thank you.
Assemblywoman Lisa Krasner, for the record. Thank you, Assemblywoman Summers Armstrong, for your question. So a couple of things. The Public Defender's Office, again, working off of the amendment in Section 1, crafted this entire section of what must transpire when a child under the age 18 is in a position where they may have to waive their Fifth Amendment constitutional right to Miranda warnings. And I think that the way that they called it out, that the consultation may be in person, by video conference or telephone, that a police officer shall not conduct a custodial interrogation on a juvenile under the age of 18 without first having the juvenile consult an attorney, a parent, or a legal guardian. The consultation must be made confidential, but may be in person, by video communication, or telephone. The juvenile must be informed that they can speak to an attorney for free. After the consultation, the police officer must ask the juvenile, did you have enough time to speak with your parent or legal guardian or attorney? You can have more time if you need it. If no additional time is needed, the police officer must ask, do you want to waive your constitutional rights and speak to me? You can say no. I have to respect that and not ask you any questions. If you do, I can tell anyone what you tell me. This means that you are waiving your Fifth Amendment constitutional right if you speak with me. If the juvenile consents, the parent, legal guardian, or attorney for the child must be asked, do you give consent to the minor to speak to law enforcement? And in doing so, waive their Fifth Amendment right to Miranda to remain silent. Do you understand that this means that anything they say can and will be used against them in a court, which could include a criminal case? If either the adult or the juvenile do not wish for the juvenile to speak with the police officer, that shall be deemed as an invocation of the Fifth Amendment right, and the police officer must immediately stop asking any questions. I feel like it's important that we have parent, legal guardian, or attorney there. Parental rights are also very important. As I mentioned earlier, an adult rapist who doesn't get their Fifth Amendment constitutional right to Miranda said to them, gets off free, according to the United States Supreme Court in the seminal case. But a child, they don't have to be given their constitutional right. They don't get to consult with their mom or dad or their guardian or an attorney. That's wrong. Thank you.
If I may, Chair Yeager, Kendra Birchie for the record, and Assemblywoman Summers Armstrong, to answer your question, that is what the case law indicates, is if a minor child or any adult at any point of their interactions with law enforcement says, I want to speak to an attorney, that means that they are invoking their rights and that the law enforcement cannot continue questioning them without the presence of their attorney. So that is our intention with this bill, is that even if they start by speaking to a parent or guardian who also may not know their rights or may not know how to proceed, that if a child then says, I want to speak to an attorney, that they are still afforded that right according to our laws, and that they will be afforded that right to speak to an attorney. And just for the committee's information, this is already taking place in communities across the nation. King County, which was a county up in Washington that was mentioned during Assembly Bill 132, they already have this program in place where an attorney is on call in order to respond to custodial interrogations and to questions.
Okay, let's go next to Assemblyman O'Neill for a question.
Thank you, Chair. I'll try to be brief on my questioning and probably be best answered by, I think, one of the public defenders who did a questionable job in representation of poor little PK. But the first question I've got, and it's basically just two, is I know what an attorney is. That's easily defined. I know what a parent is. What's the definition of the guardian here? Can it be the school principal when a juvenile is taken into custody?
Kendra Birchie for the record. Chair Yeager, through you to Assemblyman O'Neill. Legal guardian does have a specific definition in the law. If a child is taken into care and custody in 432B cases, that then becomes the social services or the human service agency in that jurisdiction. Additionally, there could be a legal guardian as determined through the guardianship proceedings. And so that is someone who then steps into the shoes, and the court has determined that for all intents and purposes, they are and should be acting as that parent.
Thank you for that. And if I may, second question, Chair.
Please go ahead.
And it's been somewhat answered already in the amendment, but it just says that either the adult or the juvenile. I was just wondering, should that be clarified since you keep talking about parent, attorney, or guardian? What happens? The adult really leaves it open now, to me. Just clarification on it.
Kendra Birchie for the record. Chair Yeager, through you to Assemblyman O'Neill, I think you raise a very valid point. And if in the writing process is determined that we need to add that additional clarification, I know that we're happy to do so in order to ensure that everyone's on the same page regarding these rights, and that if any of those parties, the parent, legal guardian, attorney, or child, decides that they want to invoke their rights, that it does actually invoke their right, the juvenile's rights.
And if I may, just to clarify, the parent says invoke, the 17-year-old says, no, I want to talk to you. It's the parent's decision that is the overrider, correct? That's the way I read it.
Kendra Birchie for the record. Through you, Chair Yeager, to Assemblyman O'Neill. That is a great question. I don't think that this law states who has the overriding. It's if somebody invokes the right, then the right is invoked.
Well, I know in an adult court, an adult can override the advice of the attorney and decide to speak. But I'm just asking for clarification here in the way I read it, that if there's any of the four, the parent, guardian, attorney, or juvenile wants to invoke, it doesn't matter what the juvenile wants. Am I reading that wrong? Under that last part of the amendment there, either the adult or juvenile do not wish for the juvenile to speak. Question should stop immediately.
Assemblywoman Lisa Krasner for the record. Thank you, Assemblyman O'Neill, for your question. You're right, that should be clarified, and I'm happy to amend that. It should be very clear that a child cannot waive their right to Miranda. Thank you.
Thank you. Thank you, Chair, for the time. I appreciate it.
You're welcome, Assemblyman O'Neill. Before we move on to testimony, are there additional questions from committee members? I do not see additional questions. Assemblywoman Krasner, Ms. Birchie, appreciate you presenting the bill. We'll ask you to sit tight for a few minutes while we take some testimony on the bill, and then we'll give you a chance to have the last word on Assembly Bill 251. So at this time, I'm going to open it up for testimony in support of Assembly Bill 251. We have Mr. Pirro with us on the Zoom. I know we helped answer questions, but I assume, Mr. Pirro, you'd like to provide supportive testimony?
Thank you, Mr. Chairman. John Pirro from the Clark County Public Defender's Office. And yes, we would like to thank Assemblywoman Krasner for bringing forward this bill. As she said previously, we treat children differently in all other areas of our law, and it's time to respect that difference in cognitive ability here. And Assemblywoman Krasner is doing that both in the juvenile Miranda portion of this law and giving children a fresh start after they may have messed up in the past so that they can go on to become productive adults and leave the past in the past. We're grateful that she's brought this bill forward, and we ask this committee to please pass this bill.
Thank you for your testimony and support, Mr. Pirro. I don't believe we have anybody else on the Zoom with us in support. BPS, could we go to the phone lines, please, and see if there's anybody there who'd like to offer supportive testimony on Assembly Bill 251?
Thank you, Chair. To testify in support of Assembly Bill 251, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 695. Caller with the last 3 digits of 695. Please press star 6 now to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good morning again, Chair Yeager, members of the committee. This is Holly Wellborn, Policy Director for the ACLU of Nevada. Thank you to Assemblywoman Krasner for bringing this bill and for her impassioned testimony this morning. Custodial interrogation is one of the most critical proceedings that may affect a child's future and their liberty. In some jurisdictions, as many as 80 to 90% of children waive their right to an attorney because they do not know the meaning of the word waive or understand its consequences. We support this bill because giving children a trusted adult and an advocate for themselves is important to supporting children during a vulnerable and extremely consequential circumstance. We also support efforts to seal the records at an earlier time, allowing kids to move forward. They're applying for colleges at that time and a variety of other, applying for employment and getting their lives started as adults. So the sooner we can seal these records, the better. We also support efforts to permanently delete charges from children's records, and we'll continue to work with the bill sponsors to find, the best mechanism through which to delete these charges from children's records as they move into adulthood. Thank you again, and we encourage you to support this bill.
Thank you for your testimony, Ms. Wellborn. BPS, let's take the next caller in support.
Thank you, Chair. Would the caller with the last 3 digits of 826 slowly state and then spell your name for the record? You will have 2 minutes and may begin now.
Hi, Chairman Yeager, James Dold, representing Human Rights for Kids for the record, last name D-O-L-D. We just want to start by thanking Assemblywoman Krasner for bringing this very important piece of legislation. This bill is critical to protecting the due process and constitutional rights of children in the justice system. We need to protect children's due process rights the most when the stakes are the highest, and that's when they are facing the potential of spending decades in prison. It's impossible for somebody to invoke their constitutional rights if they don't know what they are and if they cannot voluntarily waive them because they don't understand them. That is why the American Academy of Child and Adolescent Psychiatry has adopted recommendations that children have an attorney present during questioning by police or other law enforcement agencies, and that the American Psychological Association has adopted resolutions on criminal interrogations recommending that vulnerable suspect populations, including children, be provided with special and professional protection during interrogations. It's also worthy to note that the UN Committee on the Rights of the Child has affirmed that children should have access to legal assistance or to their parent or guardian during the interrogation process, and that's specified in Articles 37 and Article 40 of the UN Convention on the Rights of the Child. As was mentioned previously, the National Exoneration Registry shows that children are a high risk for false confessions. Nearly 60% of 14 and 15-year-old children who were later exonerated falsely confessed to a crime that they did not commit, and nearly all children under the age of 14 falsely confessed. High-profile cases like the Central Park Five highlight why it is so important to protect the due process rights of children. And lastly, I'll just highlight that from a law enforcement perspective, this bill is important because it helps to ensure that children, in fact, don't falsely confess, that there is reliable evidence in the courtroom. And, I always go back to the My Child test. If this was your child and they were arrested, what would you want done? Would you want to be notified that your child has been arrested? And would you want the opportunity to talk with them and to help advise them as they go through a process of interrogation? And so that's why this bill is so very important, and we're very much in support of it. And we hope that the committee will vote in favor of this very important legal protection for children. Thank you.
Thank you for your testimony, Mr. Dold. BPS, let's take the next caller in support.
Thank you. Would the caller with the last 3 digits of 240 press star 6 to unmute yourself and then slowly state and spell your name for the record? You will have 2 minutes and may begin now. Caller with the last 3 digits of 240, press *6 to unmute yourself and begin your testimony.
My name is Nedra Cooper, Nedracooper. As a mother of a son and grandson, I am in support of this bill for many reasons. It is unfortunately that minorities, I happen to be African American, are more likely than not to be those who are misrepresented and who are not giving the fair due process. I think it's imperative that when a child is arrested or detained, that a parent be present to help ensure that the rights of their children are not violated. There are many reasons why we would not want our children to be direct filed, and I don't want to list all of those reasons because I'm sure each of you already know that we have already established that juvenile growth development is a lot less than adults, and so therefore we need to keep that totally under consideration, and that when they are incarcerated with adults, they are highly subject to being victimized and assaulted, and they live with this they carry these traumas with them, and it affects them for the rest of their lives. We also know that it is really important that under arrest in these circumstances, a lot of these minors are afraid. They're not sure what's going to happen. Sometimes they're even given false promises that we know what helps to get a false confession. So I think that if a parent is there, and I prefer that a parent be there the minute that they need to be questioned and not asked, do you want to have your parent there or do you want to have an attorney? I think when you're under duress, sometimes you don't understand exactly what that means. And I think sometimes it may not be presented to that child in a manner that they know that they could ask for their parent. So if you're concerned, I would say that if you want to see a story about a young man who lived this life, you might want to view the story of Khalif Browder's story and see what happened to this young man. I want to thank you for being astute enough to put such a bill on the books. Introducing this bill. I really thank you for that. And I'm also in favor of expunging at 18. And please don't allow to decide that you're going to conceal because it's easier than rewriting or adding to the law. Thank you for your time.
Thank you for your testimony, Ms. Cooper. BPS, let's take the next caller in support, please.
With the caller with the last 3 digits of 188, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good morning. Gianna Verness for the record, GIANNAVERNESS. I am the Chief Deputy Public Defender supervising our juvenile division in the Washoe County Public Defender's Office. My thanks first to the Chair and the Assembly Judiciary for the opportunity to be heard today. We do support AB 251 and thank Assemblywoman Krasner for her support in addressing these very important issues. Requiring youth to have the opportunity to consult with an attorney or a parent or guardian before waiving their Miranda rights and participating in a custodial interrogation is extremely important. Juveniles are different. As you heard from Assemblywoman Krasner, the U.S. Supreme Court has recognized this fact. They are generally less mature and more impulsive than adults, and they have a very limited understanding of the criminal justice system. The research we have also tells us that juveniles generally do not comprehend long-term consequences of the actions they take today. Participation in a custodial interrogation requires the child to waive individual constitutional rights that most do not understand. During my tenure with the Public Defender's Office, I've had the opportunity to interview hundreds and likely a lot more juveniles and discuss what Miranda rights are and what they mean. When asking the youth their understanding of what the Miranda rights mean, the typical response is usually some variation of, I cannot talk back to the police officer. I cannot speak out of turn. That I must sit there, be quiet, and answer the officer's questions. Youth simply do not understand these rights, and nor do they comprehend the consequences of waiving them. As you heard Assemblywoman Krasner note, we as a society do have standards and laws that treat youth differently. Children cannot get married without parental consent. They cannot enter into contracts. They can't even obtain a driver's license without parental consent, and there are a lot more. However, currently in Nevada, a child as young as 8 years old may waive their individual constitutional rights without consulting a parent, a guardian, or an attorney. We also support the lowering of the age for automatic sealing of juvenile records to 18. This change will allow youth who are no longer active in the juvenile justice system the chance to move into adulthood with a clean slate, and without the concern that the transgressions they committed in their youth will follow them into their adult life. We urge you to please consider passage of this bill. Thank you again.
Thank you for your testimony, Ms. Verness. BPS, let's take the next caller in support.
With the caller, with the last 3 digits of 130, slowly state your name and then spell it for the record. You will have 2 minutes and may begin now.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINE SAUNDERS, and I'm a policy director with the Progressive Leadership Alliance in Nevada in support of AB 251. First, I want to thank the Assemblywoman for bringing forward this bill and for proactively reaching out to community leaders for their input. We believe that all youth should have access to the resources they need to navigate the criminal justice system. AB 251 will help increase fairness and better ensure justice for youth in Nevada. We urge your support of this legislation. Thank you.
Thank you for your testimony, Ms. Saunders. BPS, let's take the next caller, please.
With the caller with the last 3 digits of 037, please slowly state and then spell your name for the record. You have 2 minutes and may begin.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. We would like to thank the chairman and the members of the Judiciary for bringing this bill forward, along with Assemblywoman Krasner. Thank you very much for this bill. We are in support of this bill. I would just like to echo the comments made by the previous callers, and that we do believe that this will help prevent wrongful convictions. Thank you, and have a wonderful day.
Thank you for your testimony, Ms. Brown. BPS, let's take the next caller in support, please.
With the caller with the last 3 digits of 338, press *6 to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good morning. Nathaniel Erb, NATHANIELERB, for the record on behalf of the Rocky Mountain Innocence Center and the Innocence Project in support of AB 251 as amended. We want to thank Assemblywoman Krasner for putting this bill forward. The Rocky Mountain Innocence Center and the Innocence Project work to prevent and address the causes of wrongful convictions in Nevada and throughout the United States. It is for these reasons that our organizations respectfully request the committee pass AB 251. It is our organization's submitted testimony. We focused on the aspects of the bill related to interrogations, but we fully support the bill as amended as a whole. AB 251 will provide important protections against wrongful convictions of children in Nevada in a myriad of circumstances. One of the most serious circumstances it would protect against is false confessions. Of the cases tracked by the National Registry of Exonerees, 49% of false confessions were of children under the age of 21 at the time of arrest. Wrongful confessions by 4 wrongfully convicted adults in Nevada alone point to the compounded vulnerability of children to this same issue, which demands better protection under Nevada law. Children do not have this mental maturity to judge the consequences of confessions in the way adults do. They are more likely to focus mainly on the immediate potential outcomes of making a false confession, such as going home. Juveniles also may be more inclined to please authority and are more susceptible to manipulation, from leading questions to threats. By requiring that children consult with attorneys or their parents or guardians prior to an interrogation, AB 251 protects against false confessions and statements that may lead to a wrongful conviction and have led to wrongful convictions in adults in Nevada. It is for these reasons that the Rocky Mountain Innocence Center and the Innocence Project support AB 251 and request its passage by the committee. Thank you for your work on this bill.
Thank you for your testimony, Mr. Earp. BPS, if there are other callers in support, let's take the next one, please.
Thank you, Chair. Yes, with the caller with the last three digits of 007, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
This is Lisa Rasmussen, Rasmussen, and I'm testifying on behalf of Nevada Attorneys for Criminal Justice. Good morning, Chairman Yeager and Assemblywoman Krasner. I want to thank Assemblywoman Krasner and all of the co-sponsors for supporting this really important litigation. As others have mentioned, we don't allow children to enter into contracts prior to age 18 for a reason. So it stands to reason that we wouldn't allow them to make important decisions about their constitutional rights without first consulting an adult. We know from all of our litigation that we've been doing and all of the legislation we've passed in recent years that juvenile brains are different. And we also know as citizens that children are some of our most vulnerable populations. This bill is similar to what other jurisdictions have done. The amendment is particularly well done because it addresses many of the questions that I've listened to here this morning on this bill. I just want to highlight a couple things in response to some of those questions. One is on the issue of expungement. It's very important to note that there is a judicial review process associated with expungement, and a court will be deciding whether juvenile offenses should be expunged and basically completely eradicated from the record. So it's not the legislation that does it, it is a court who will decide. And it also, as Mr. Pirro pointed out, does not apply to sex offenses, murders, things of that nature. On the, there's been a lot of questions about what's custodial interrogation. The answer to that is when you're not free to leave. That doesn't get litigated. What does get litigated are the facts surrounding whether someone was not free to leave. So, and I think that it's important to clarify because that standard is clear in the law. It's the facts about whether someone was free to leave or not free to leave that are the aspect that gets litigated. And on the issue of Miranda itself, without this bill, what currently often gets litigated is whether or not a child who says something like, I want to talk to my mom, whether that's an invocation of Miranda. This makes it clear that he has an absolute right to talk to his mom, and it takes away the need to litigate whether saying, can I talk to my mom, can I talk to my dad, is a child or juvenile invocation of Miranda. So this bill is really well done, in particularly so with the amendment that Assemblywoman Krasner has proposed, and I would urge all of you to support it. Thanks for letting me talk.
Thank you for your testimony, Ms. Rasmussen. BPS, if there are other callers in support, let's take the next one, please.
Thank you. With the caller with the last three digits of 087, slowly state your name and then spell it for the record. You will have 2 minutes and may begin.
Jared Luke, Jaredluke, Government Affairs Director for the City of North Las Vegas. Chairman and members of the committee, I appreciate the time to speak in support of AB 251. I also want to thank Assemblywoman Krasner and the other sponsors of this bill for bringing it forward. Mayor and Council of North Las Vegas have made protecting and educating our young people a high priority. And so the legal process for an adult can be very complex and confusing. So I commend the bill sponsors for their wisdom and providing a bill that will help young people navigate a complex process. Thank you, Chairman, for your time.
Thank you for your testimony, Mr. Luke. BPS, are there other callers in support?
To testify in support of Bill AB 251, press *9 now to take your place in the queue. With the caller with the last three digits of 580, press *6 now to unmute yourself and begin your testimony by stating your name and spelling your name for the record. You will have 2 minutes and may begin now.
My name is Darren Imlay, D-A-R-I-N. Last name is I-M-L-A-Y. I am the public defender for Clark County. Appreciate the opportunity to speak. Thank you, Chairman Yeager. Thank you, Assemblywoman Krasner. I just want to say the Clark County Public Defender's Office absolutely supports AB 251. We have seen, when I ran the juvenile division, especially interviewing a number of kids and being involved with the kids, the importance of them knowing their rights. Adults have a difficult time understanding their own constitutional rights. The Miranda warning, you could tell by many of the questions today, it's confusing and difficult. So imagine a 16-year-old that doesn't have that understanding, but potentially facing, with certifications and things like that, an adult sentence, many years in prison. It's absolutely vital that they are aware of their rights, they have the opportunity to consult with an attorney prior to waiving those rights. And based on that, we are absolutely in support of AB 251, and I'd urge this committee to pass it. So thank you for the time.
Thank you for your testimony, Mr. Imlay. BPS, let's check if there are other callers in support, please.
To testify in support of Bill AB 251, press *9 now to take your place in the queue. Chair, there are no more callers in support of AB 251 at this time. Oh, stand by. We have somebody who came in late. With the caller with the last three digits of 159, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, my name is Amy Holdridge, AIMEEHOLDREDGE. Can everybody hear me?
Yes, we can hear you. Please go ahead.
Thank you, Assemblyman Yeager, and thank you to the rest of the committee members. I'm sorry I didn't hit the *9 to get into the queue. I'll be quick. I am in Clark County. I am a mother of two young boys, and I just want to say that I could not imagine not being contacted if my children found themselves on the wrong side of the law and in custody, and I would be incredibly furious if I could not support my children, advise my children, and be able to provide representation for them in that situation. And I just don't know how I can teach my children to respect the law and respect authority if they're not given basic rights to protect themselves if they do get into some trouble. So I thank the sponsors of this bill for bringing it forth. And there's so much in it that is so important for our children, to treat them as human beings and give them that shot in life if they do get into trouble, to be able to really become something and become a good part of society, even if they find themselves into some trouble when they're young. Thank you for bringing forth this bill, and I hope it does pass. And thank you, everyone, for letting me speak.
Thank you for your testimony, Ms. Holdridge. BPS, let's check one more time to make sure there's nobody else in support.
Would call-in user number 2 press *6 to unmute yourself, and you have 2 minutes to speak. You can give your name and spell your name for the record, and you may begin now.
Am I being called? Can you hear me?
We can hear you. If you are in support of the bill, please go ahead and state your name and provide your testimony. Caller, were you in support of the bill? Go ahead, BPS.
I was going to say, caller user number 2, if you want to testify in support, press *6 to unmute yourself and provide your testimony in support of Bill 251. Chair, at this time, there are no more callers in support of Bill 251.
Thank you so much, BPS. I'm going to now close testimony in support. I will open it up for testimony in opposition. We don't have anyone on the Zoom in opposition. BPS, let's go back to those phone lines and see if there's somebody there who'd like to testify in opposition.
To testify in opposition of Bill AB 251, press star 9 now to take your place in the queue. And we will begin with call-in user number 3. Please state your name and spell your name for the record. You will have 2 minutes and may begin now.
Hello, Mr. Chairman, members of the committee. This is Chuck Callaway, Callaway, representing the Las Vegas Metropolitan Police Department. Unfortunately, we're here today in opposition to AB 251. Our officers do carry the juvenile Miranda cards, and we do make every effort when we contact juveniles to notify parents that their child is in custody. However, there are many situations that might occur out there. Sometimes parents are not home or they're not available. Sometimes the juvenile is afraid, and so they lie and give a false number and make it difficult to contact parents. And basically, as was stated in the testimony, this bill makes it so that a person under 18 cannot waive their Fifth Amendment rights at all. And every situation is different. And obviously, 11 or 12-year-old is a completely different scenario than somebody who's 17 plus and turns 18 in a couple months. And I understand that Assemblywoman Krasner's heart is in the right place, but my fear is that this bill will actually cause more harm than good. We have situations where it's by our policy that we work with kids, we divert them from the criminal justice system. We use the harbor and the family justice courts and family justice center down in Clark County. And to just give you one example, if we had a case where a fight occurred between a 17-year-old and a 22-year-old, and an officer arrives on the scene, we can't, based on this law, we can't even get the side of the story of the 17-year-old without having a parent contacted, without getting hold of an attorney potentially if a parent's not there. And as was the concerns raised by Assemblyman O'Neill, this 17-plus-year-old would not even have the ability to waive their own rights and decide they want to speak with us about what happened. And so my fear is that in these cases, if we can't get a hold of a parent and we can't get a hold of an attorney, we'll simply make an arrest and take the juvenile to juvenile hall, and there won't be an opportunity to maybe smooth out a situation or avoid that consequence from happening. So as I said, I understand the intent of the Assemblywoman, but unfortunately, as the bill is written and specifically with the amendments, we are opposed. Thank you, Mr. Chair.
Thank you for your testimony, Mr. Callaway. BPS, let's take the next caller in opposition, please.
Thank you. Would the caller with the last 3 digits of 705, please press star 6 now to unmute yourself and slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning. My name is Elizabeth Flores, Elizabeth Florez, and I am the Interim Director of the Washoe County Department of Juvenile Services. I reached out to the sponsor yesterday and appreciate her offer to meet with us regarding our concerns, but we were not able to do so before today's hearing. AB 251 has 2 distinct elements. The first is to require that youth consult with either a parent or attorney prior to custodial interrogation. The unintended result of this bill will likely be that officers in the field during the course of an investigation will be unable to ascertain which youth can be eliminated as suspects, creating a situation where all will be arrested and brought into custody. It is also unclear if this requirement would apply to probation officers who in the normal course of duties meet with juveniles at the office, in their homes, and in the community. Juveniles are required to meet with their POs as a condition of probation. These meetings are not necessarily voluntary. As written, this would greatly hamper the relationship we establish with the youth we serve and the court's orders we are required to follow. For those in custody, youth will likely remain detained for longer amounts of time awaiting either parental consultation or assignment of legal counsel. It is understood that increasing research around adolescent brain development suggests that youth may not have the capacity to waive their Fifth Amendment rights against self-incrimination. However, as written, this bill may create harm. The second element is regarding sealing and destruction of records. It is unclear as written if youth who are currently under the supervision of juvenile court with multiple distinct open cases would fall into this requirement. 62B 410 allows juvenile jurisdiction until the age of 21. If a youth is placed on probation at 17 years 11 months, supervision may extend beyond the 18th birthday. The recent proposed amendment allows youth to petition for the expungement of all misdemeanor offenses, but not all misdemeanor offenses are created equal. For example, brandishing a weapon in a threatening manner, domestic batteries, DUIs, stalking, and violations of TPOs are misdemeanor offenses. As a probation department who continues to embrace juvenile justice reform and who continue to divert the vast majority of youth away from formal court proceedings, and who pride ourselves in developing relationships with them, we fear this legislation will result in extended detention time for our youth and will compromise public safety. Thank you.
Thank you for your testimony, Ms. Flores. BPS, let's take the next caller in opposition, please.
With a caller with the last three digits of 210, press star 6 to unmute and slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Michael Wheelhan, Michael Wheelhan, Clark County Department of Juvenile Justice Assistant Director. I would like to thank the committee for their time. DJGS opposes the bill, but supports the ideas of the juvenile rights. Custody for a peace officer can be placing a youth into handcuffs or giving them a verbal command to stay in the car, room, etc. The language is very broad and confusing. The difference between custodial and detainment are different, but in this language, it's unclear as to when the rights would occur. The unintended consequence of this bill would lead more youth to being detained or arrested. Probation officers' primary roles are to protect the community, role model and mentor and build relationships with children. This would be hard to do without having conversations. Violation of probation arrest will increase. In 2019, our violation of probations dropped nearly 20%. An example would be a GPS violation where kids has an ankle monitor on, leaves the home, and goes to 7-Eleven. Parents not home. We go by the house to see what the kid's doing. We can't even ask a simple question, why did you leave your home? A simple drug test where it tests positive for opioid, we can't ask the child, did you have to take a prescription of your parents, or did you have a poppy seed muffin? So the unintended consequences, these children will be detained. Clark County has a program called the Harbor, which has diverted over 15,000 youth since its exception in 2016. And there are probation officers that work there that help process these cases. Many misdemeanors are diverted. The Harbor is a successful multi-agency approach to diverting youth from entering the juvenile justice system. Questions, needs, and risk assessments are often used to determine appropriate resources and services are provided to the youth and family. DGJ has diverted over 5,700 cases out of their 11,700 in 2019. The Harbor will be significantly impacted, as will the efforts made by juvenile justice to divert youth. If a parent or attorney does not answer the phone, a schedule will have to be made and could be several days to a week later. Unnecessary detainment of youth will occur. An example would be domestic violence in the home. Often the children are victims, and if the parent and a step-parent are involved in this, police officers cannot even ask the child, were they the victim or were they a perpetrator? AB 132 is a similar bill that has a similar impact to juvenile detentions in the state. There's other bills that are pending, certification bills that would add more youth to detention. Many detention facilities in the state of Nevada have limited bed space, as does Clark County. This could cause overcrowding and concerns for our juvenile detention facilities and our efforts to keep kids out of the system. DGJS also has concern about the bill when it comes to the automatic sealing of records. What is the impact for when a child has a hold open charge or is currently on probation past the age of 18? Would these charges be sealed and the child would not be able to get the services that they need prior to getting off probation. Thank you for your time.
Thank you for your testimony, Mr. Wheelahan. BPS, let's take the next caller in opposition, please.
Thank you, Chair. Would the caller with the last three digits of 822 press *6 to unmute, and then slowly state and spell your name for the record? You will have 2 minutes and may begin. Caller with the last three digits of 882, press *6 to unmute yourself and begin your testimony.
Good afternoon, Chair Yeager and members of the Assembly Judiciary. This is Bridget Duffy, BRIGID, DUSSY, Chief of the Juvenile Division for the Clark County District Attorney's Office, appearing today on behalf of the Nevada District Attorney Association. Unfortunately, this morning we are coming in opposition to this piece of legislation that is taking some steps to juvenile justice reform. The Clark County Juvenile Division strongly supports juvenile justice reform, but unfortunately, with the timeframes that we will receive this piece of legislation and specifically the amendments, we were unable to have a meeting with the Assemblywoman to discuss our concerns and come to some consensus. So just to state my opposition on the record on behalf of the District Attorneys Association, I want to state in Section 1, that section ignores that some of our children are foster children that come into the juvenile justice system. And I disagree with Ms. Birchie that the term guardian would envelop the child welfare agency. The child welfare agency is not a legal guardian of a child. Children are placed into the custody of a child welfare agency, making them the legal custodian. It is a specific term of art, and therefore Section 1 would not apply to a child welfare agency child who may not have a parent. Also, in the past, we've had the similar bill in different sessions where there was a lot of testimony from our public defenders around concern that if the children had to consult with their parents prior to waiving their rights, that the parents would influence the children to waive their rights. And there was a lot of opposition to that. So I just want to make sure that we're addressing that issue, that if the issue is that the child gets the opportunity to consult with a parent or an attorney, and the parent is standing there, is that really what everybody wants? Because in the past, there was a lot of opposition to that. And I've spoken to a lot of my juvenile public defender friends around some of the problems that they have with parents influencing their child's juvenile justice case. Also, while I applaud the public defenders for being available by phone 24/7, many of our cases have multiple co-defendants. So, for example, in the middle of the night, I may get a call about a series of robberies in a casino. Specifically, we've had one recently with 5 children pepper spraying elderly in the parking lots of casinos, disabling that elderly victim and taking their property, including their vehicles, to drive to the next casino to do the same thing. There were 5 co-defendants in that case. So going with the thought that a public defender may be available for one of them, oftentimes public defenders are conflicting off. They can't represent all of those co-defendants at the same time. So I think we need to address that issue and make sure we have the resources available. Current constitutional protections under U.S. and Nevada Supreme Court case law puts the burden on the state to prove a waiver of Miranda and voluntariness of a statement under totality of the circumstances. Just so this committee knows, one factor is the juvenile's age and another is the presence of the parent. And per Nevada Supreme Court decision, police cannot mislead juveniles after reading their Miranda rights. So while I know I only have 2 minutes, so I'm trying to speed it up. I also love the banter because it makes these really long hearings way more exciting and entertaining. But I just want to make sure the record is clear. We have hearsay, which is an out-of-court statement, and there are exceptions to hearsay like excited utterances and party admissions, and we have Miranda. So I don't want this committee to confuse hearsay and statements made after a Miranda. For example, at a car stop with a broken taillight, unsafe lane change, an officer approaches a vehicle, the 16-year-old screams, "I have a gun in my pocket." That is hearsay and arguably an exception. Miranda would be after the officer takes that child out of the car, puts him in handcuffs, and then provides him his rights not to speak to him. And so I just want to make sure the record's clear, because while I love that people, all of us, have had some sort of juvenile record, well, I'm not going to say all of us, but that that we understand the difference between an out-of-court statement under hearsay and a statement after a Miranda is read. Finally, good policy to allow children to seal their records and move on. We all make mistakes. We all make poor decisions as children, as adults. What is important is that we teach our children that they accept their consequences, and they learn from their mistakes, and they don't let it define their future. How I teach my children, it's how I teach the foster children and the delinquent children that I handle every single day. You don't want to make a mistake you can't come back from. You make a mistake, you learn from it, you take your consequence, and you move on. Never let it define your future. So I appreciate that we are clarifying that we want children to be able to move on. I just need this statute to be very clear that it is not intended to seal cases where we are still providing rehabilitative services to children. I don't want to close cases prematurely. We do have a section under the statute for child victims of sex trafficking that automatically seal at 18. I want to make sure we are very clear that this is not the case, because the reason to address, I believe it was Assemblywoman Kasama's issue about why 21 in the past, juvenile court has jurisdiction until 21. That is very significant because children may be arrested at 17 years old and 11 months for offenses for which we really want to provide them with rehabilitative services so that they can go on and be productive children and put my criminal division out of business, right? If I get you at 17 for committing an act and we provide services, I don't want that case automatically closing at 18. So we allow them to stay in juvenile court jurisdiction until 21 and receive services. So that is our goal, and why 21 was before, because it's automatic. We have case management systems that at 21 seal the cases. So just so you know, I need to make sure that we don't have any issues there. I want to support Ms. Flores from Washoe County Juvenile Justice Services. We are embracing juvenile justice reform. I am so proud of the steps that we've taken to come forward and move on. I look forward to working with Assemblywoman Krasner and my colleagues from the Public Defender's Office to work off this good foundation of policy, but make sure we are not having any unintended consequences. I see some solid opportunity here, and I appreciate the opportunity to speak in opposition. And I appreciate Chair Yeager that I know I rambled on more than 2 minutes. So thank you very much.
Thank you for your testimony, Ms. Duffy. It was more than 2 minutes, but I wanted to give you adequate time to make your points in opposition. I know things are a little different with the Zoom meetings and the call-in, so appreciate those comments. BPS, I think there might be one or two others in opposition. Could we go to the phone and check on that, please?
Thank you, Chair. Would the caller with the last 3 digits of 241 slowly state your name and spell it for the record? You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary Committee. My name is Alex Ortiz, ALEXORTIZ, representing Clark County. Even though this is a policy committee, it is our only opportunity to express our concerns about the fiscal impact on Clark County. Clark County opposes Assembly Bill 251 as written and amended due to the fiscal impact on Clark County. I did reach out to the sponsor yesterday, but was unable to connect with her and discuss our concerns, specifically related to our Department of Juvenile Justice Services. My opposition is only based on the fiscal impact to the county and not the policy issues discussed today. Some of our policy concerns were mentioned by our Assistant Director of the Department of Juvenile Justice Services, Mike Wheelahan. To my knowledge, we were not asked to submit a fiscal note on this bill. However, the fiscal note of this legislation is significant on our Department of Juvenile Justice Services and will necessitate opening, staffing, and operating an additional housing unit in juvenile justice detention at the cost of over $2 million a year. I want to thank you, Chair Yeager, Vice Chair Wynn, and the members of the Judiciary Committee today for taking time to listen to my testimony. Thank you.
Thank you for your testimony, Mr. Ortiz. BPS, is there anybody else in opposition?
To testify in opposition of Assembly Bill 251, press *9 now to take your place in the queue. Chair, at this time, there are no callers no more callers in opposition of the bill.
Thank you, BPS. I'm going to close opposition. BPS, before we go to neutral, I wanted to take us back for support and just check. I'm under the belief that perhaps Ms. Wildevelt has been on the phone and is wanting to testify in support. I don't know if that's the case, but could we go to the phone line just to see if she is there, and if so, allow her an opportunity to provide testimony?
Yes. Would you please press *9 now if you are waiting to testify in support of Bill 251? All right. So that would be call-in user number 4. Call-in user number 4, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Can you hear me?
We can hear you. Please go ahead.
Can you hear me? Okay, thank you. Thank you. Good morning, Chairman Yeager, Assemblywoman Krasner. My name is Christina Wildeveld, Wildeveld, and I am testifying as a private criminal defense attorney in support of AB 251. This piece of legislation should be important to all of us. Section 1 would require a peace officer or probation officer to consult with parents or an attorney before an interrogation is conducted. And Sections 2 through 9 actually allows a juvenile to put their juvenile behaviors behind them by sealing their records at 18, and further provides a mechanism to reevaluate a child's record after their 18th birthday to allow parties to seal previously unsealable records. It recognizes children, as Assemblywoman Krasner indicated. As someone with extensive experience working in the juvenile justice system, I can attest to the fact that our system still needs improvement. We encounter kids in the juvenile system that are often experiencing great crisis in their life, not only because they are dealing with ordinary juvenile issues, but also issues that include homelessness, substance abuse, and undiagnosed, untreated mental health conditions. Children are brought into custody for everything, including a fight at school, graffiti, or homicide. The focus on representing a child in juvenile court includes helping them deal with their life problems to ensure that they do not return to court. The model of adult court is not the same, and representations in the adult court are much different than the representations of a child in juvenile court. The juvenile system is focused on rehabilitating a child, not tricking them. Children under arrest do not understand Miranda warnings and are only familiar with the words they know from television. The warnings for children include asking a child if he or she would like a parent or an attorney present. Under this bill, the child cannot waive counsel or a parent present at that point. They are not given a choice that they do not understand. Instead, it recognizes that children are different from adults. The Supreme Court has recognized that teens are too young to exercise, let alone comprehend their rights, so they become easy victims of the law. This legislation fixes that and recognizes that children are in fact different. To waive that right is a powerful thing that children in this situation do not understand, and provides for procedural protections for juveniles while recognizing the characteristics of youth. Sections 2 through 9 remind us that juvenile justice is centered on rehabilitation, and the system is supposed to be designed to ensure that the underlying issues that contribute to delinquent behaviors are addressed while the individual is still a youth. Studies have consistently shown that juveniles have a higher chance of achieving rehabilitation than their adult counterparts, and that because a juvenile's brain is still developing, it is easier for a juvenile to change his or her behaviors. Therefore, the acts that one commits while still a juvenile should not be used against them if they have contact with the system again as an adult. Instead, it is consistent with what we preach to kids in the juvenile court. We are here to help you. Not, but if we can't, we will make sure this comes back to haunt you in the future as an adult. Until we fix our inadequacies in the juvenile system, the lack of options to help kids in the system, we need to put safeguards like this in place. Some youth are facing lifetime sex offender registration, even if they stay in the juvenile system. As mentioned, there are collateral consequences to having a felony adjudication in the juvenile system that may impact college applications, scholarships, employment, housing, and future arrests. There are some situations, real situations, like one I am currently dealing with in a case in Lovelock, the case of Matthew Hutchinson. Our client was arrested months after his 18th birthday, 53 days, I think, to be exact. He was offered a deal that considered parole because of his juvenile history, which consisted of delinquent acts as well as typical juvenile acts, including plugging the toilets in juvenile detention, name-calling in juvenile detention, throwing pencils in juvenile detention. The judge in the case sentenced him to life without the possibility of parole rather than what the negotiations contemplated. The court 13 years ago relied on records that, if they had been sealed on his 18th birthday, would not have been used to sentence him to life without possibility of parole, which he is still serving today. He also would not have falsely confessed if he had an attorney or a parent present when the police questioned him. Matthew Hutchinson now, 14 years later, is a grown, mature, and different individual than the one that was sentenced based on a juvenile history and without consultation of an attorney, which should have remained just that, history. His adult counterpart received 7 years for the same offense. It is incredibly important that our state keeps abreast of the latest trends, data, and research concerning juvenile rehabilitation, and this bill is another step in the right direction. This bill will help to make our juvenile justice system more effective and to really give meaning to the words childhood matters, and show that when we call a child a child, he cannot then have his childhood used against them once they magically become an adult at age 18. I know that Ms. Duffy answered the questions about the age of 21, and again, this would mean that all juvenile records would be automatically sealed at 18, and only those that contemplate still being on a probationary term until their 21st birthday would remain unsealed unless sealed by the court. I strongly urge your support of AB 251, and I thank you for recalling me after I spent 3 hours on hold.
Thank you for your testimony, Ms. Wildevelt. Thank you for your patience this morning. BPS, I'm going to close supportive testimony. Let's go to neutral testimony on Assembly Bill 251. We don't have anyone on the Zoom in neutral. BPS, is there anyone on the phone who'd like to offer neutral testimony?
To provide neutral testimony on Bill AB 251, please press star 9 now. Chair, there are no callers to offer testimony in the neutral position on Bill 251.
Thank you so much, BPS. I'm going to close neutral testimony. At this time, I'm going to hand it back over to Assemblywoman Krasner and Ms. Birchie to make any concluding remarks on Assembly Bill 251.
Thank you, Chairman Yeager and members of the Judiciary Committee. Assemblywoman Lisa Krasner for the record. AB 251 isn't just about giving a child a fresh start and a second chance. This is also about parental rights. Just think about it. An adult rapist must be informed of their Fifth Amendment constitutional rights or they go free. But a 17-year-old son or daughter of yours who gets caught drinking a beer, which is a misdemeanor, will be arrested, taken to jail, and questioned without your consent. This is wrong. I urge you, please support AB 251. Also, I thank the two people that have contacted me and would like to be added on as co-sponsors, Assemblyman Orentlicker and Assemblywoman Bilbray Axelrod. If anybody else wants to sign on as a co-sponsor, everyone is welcome. Thank you.
Thank you. Ms. Birchie, would you like to give concluding remarks?
Thank you, Chair Yeager. Again, thank you to Assemblywoman Krasner for bringing forward this extremely important bill to help put in safeguards to ensure that we are not wrongfully convicting our youth. It is disheartening to hear from the opposition that law enforcement feels that their only option is to arrest youth when they cannot engage in custodial interrogations on scene or immediately. We disagree and think that there are other options available in order for law enforcement to continue with their investigation. I would also just note that this bill does not require for an attorney and a parent to be present. The language in the bill indicates that the officers must reach out to to the parent or legal guardian or the attorney. If a parent is not available, there would be an attorney present. I would note that the concerns regarding conflict of interest, we've been able to resolve those in other cases, and we will certainly be able to resolve those issues if we are called upon for multiple individuals at a time. I do note that there are some concerns regarding the language, specifically with some terms, and I appreciate that conversation and look forward to working with the stakeholders and Assemblywoman Krasner to ensure that we are covering all bases to fill those gaps to ensure that we are protecting our children. Thank you.
Thank you so much, Assemblywoman Krasner, Ms. Birchie, for presenting Assembly Bill 251. We appreciate it and hope you have a great rest of the day. At this time, I'll close the hearing on Assembly Bill 251. Committee, that takes us to our last item on the agenda, which is public comment. By way of reminder, we reserve up to 30 minutes for public comment at the end of each meeting. Callers on the public comment line will have 2 minutes to provide public comment. Public comment is a time to raise matters of a general nature under the jurisdiction of the Assembly Judiciary Committee. BPS, let's go to the phone lines and see if there's anybody who'd like to give public comment this morning.
To provide public comment, press star 9 now to take your place in the queue. All right, we will begin with the caller with the last 3 digits of 777. Caller with the last 2 digits of 777. Press star 6 now to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager and Vice Chairwoman and members of the committee. My name is Ben Innes. That is BENINESS. And I'm a graduate student in UNR School of Social Work, as well as an intern with the Progressive Leadership Alliance of Nevada. As many of you know, the federal and state eviction moratorium are set to expire on March 31st, a mere 2 weeks from today. Meanwhile, according to the Gwynn Center, hundreds of thousands of Nevadans are at risk of eviction, and Nevada will experience eviction surges statewide. Without increasing tenant protections, this looming crisis will hurt those who are most vulnerable in our state. That's people of color, undocumented renters, as well as low-income individuals and families. These communities have already been disproportionately impacted by COVID-19 due to job loss and economic insecurity at no fault of their own. It has been 1 year since Nevada officially recognized the COVID-19 pandemic. Although a recovery seems closer than ever, I urge you to take these steps so that no Nevadan has to fall through the cracks and be left behind. You have the opportunity to do so by implementing the protections in AB 141 and AB 161. Thank you.
Thank you for your public comment, Mr. Innes, and you have a very good last 3 digits of your phone number, 777. I think that's the first we've heard that this session. BPS, is there anybody else who'd like to give public comment?
Yes, Chair. With the caller with the last 3 digits of 556, slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was 38 years old when he was hogtied and asphyxiated to death by Reno Police and Washoe County Sheriff's Office. Today I want to talk about Philip Serrano, who was killed by Reno Police also. Philip Serrano was 44 years old when he was shot by Reno Police and killed on September 23rd, 2018. Philip was under the influence of drugs and his sister had called police. Police approached Philip, asked him if he needed help. He told them he didn't want their assistance and tried to leave. DA Chris Hicks didn't release any body cam or his justification of Philip's murder until 11/4/2020. And Philip was murdered in September of 2018. He waits for a reason he hopes the community will forget. I can assure you Philip's daughter Desiree and sister Michelle will never be able to forget. Their loved one in crisis was shot multiple times. 51 shots were fired in total by Officer Brandon Nagel, Sean Manning, Vincent Robles, Stephen Smith, and Sean Swartz. The report states that multiple witnesses indicated Philip indicated through his vehicle window he was going to park his vehicle on the curb and speak with police. As his vehicle slowly rolled towards the curb, officers unloaded on Philip.
These people I talk about in my brother's life mattered. They are someone's brother, sister, friend, lover, son, daughter. Please do not support bills that further protect police. Please support bills like AB 268, AB 271 that provide transparency and accountability for law enforcement. My family and so many others are counting on you. Thank you.
Thank you for your public comment, Ms. Grant. BPS, is there anybody else for public comment this morning?
To provide public comment, please press star 9 now to take your place in the queue. Chair, the public lines are open and working, and at this time, there are no callers to provide public comment.
Thank you, BPS, for helping us get through a lot of testimony this morning. I'm going to close public comment. Anything else from members of the committee before we talk about the rest of the week? Don't see anything. I want to thank you all. It was a long meeting this morning. I wish I could tell you that the meetings would be shorter the rest of the week, but I'm not so sure that's going to be the case. Right before we started this morning, we released agendas for the rest of this week, so you should be able to find those on Nellis, and they're likely in your inbox. We will be starting at 8 o'clock in the morning the next 3 days. We have one bill on tomorrow's agenda and then two bills each on Thursday and Friday's agenda. And then as we get towards the end of the week, we'll talk about what next week will look like. Do want to remind members we have a floor session at 11:30 today. I think there are a number of bills we'll be introducing, so I want to encourage you to try to get down there for hopefully an on-time start. Thank you again, members. We will see you tomorrow morning in this committee at 8 a.m. This meeting is adjourned.